Prosecutions are undertaken before magistrates and appeals before the then High Court and then, of course, the Court of Appeal. So when I read about the history of the judiciary and the words used in the transformation manual, I identify with it. I know what the judiciary was. I know how it was not responsive. I know how it was not people-centered. I know how it was generally seen to be, in civil matters, the preserve of those who had money. And I saw how, of course, those who didn't have money got shortchanged. I mention this because very often a state council defending a conviction or a position taken by the lower court would be alone against an ordinary citizen who had no counsel. And I'm not talking about those on capital convictions where there would be a pauper brief assigned to an advocate. I'm talking about a citizen against you. You know, there's no equality of arms. But as a state council, having the heart to sometimes defend the convict. And when I say defend, plead the case of the convict. And I'm talking about a situation where you look at a record of appeal, and somehow, despite the conviction and the sentence of several years in prison, or even the sentence of death, you can't find the evidence to support the conviction. And in the role of a state council, it would be your responsibility to easily and happily concede to the fact that the conviction cannot stand. So I am alive to what the judiciary was at the time. I moved then to, having resigned in 1992, I went into private practice. I set up a practice from scratch. When I say scratch, I mean scratch. A couple of desks this size, one for the secretary, very thin walls as partitions. I think I recall we borrowed a couple of 100,000 shillings and set up the office. I have all these years been able to grow that practice until it is a well-known practice. It has been fairly large. Through this practice, we have handled, mentored many students, many advocates who have worked with us and left, and kept the flag flying. In this practice, I have handled many briefs. I have represented a president of the Republic. I say this and it'll become relevant later. What am I saying? I don't belong to the category that will look at the President of the Republic as some godlike figure. I look at the President as a person who I can speak to, who can communicate. And in the case of that particular President, Daniel Arap Moi, the late, he was a good client and he took legal advice. He would ask twice, so is that your advice? But that is in passing. I go on to explain one or two other briefs that put me in contact with various other arms of government. I personally handled the famous or infamous, the briefs that arose from the infamous Goldenberg scandal. And this was a brief that was passed to me on account of my public service experience, my diligence, my commitment, despite all the temptations that would go with such a brief. In that brief, I don't want to go into the merits of it, I came in contact with ministers, with governors of central bank, and other powerful individuals. It was a classic case where it took collaboration between agencies within government to succeed. And I must say, this in passing, when I handled those briefs, His Lordship, the late Justice Coker, was the Chief Justice, and it was a very happy experience. Cases were handled fairly expeditiously and with a fair measure of success. I say this because, and perhaps this is something that will feature later on in the interview, the administration of a particular Chief Justice defines the output, the expectation from that judiciary. And I say this with great respect to the departed Chief Justices who I'm going to refer to. Central Bank or not had a fair measure of success in some of its cases under one administration. And when there was a change of administration, and we had a different Chief Justice after Justice Coker, suddenly the fortunes in those cases changed. And I will say this because it's a matter of record. And certain judges who had ruled in a certain way shortly before ruled in a different way. I can only say that it is what the leadership of the time showed to the judiciary, gave you a sign about what was permissible and what was not. I don't want to say more for legal reasons, but that is the story of the Goldenberg cases through the courts in our country.
Maybe Senior Counsel,
yes.
I could pick it up from there about leadership, because you have talked about the different people and their leadership styles, and ask you, if you became CJ, what is your leadership style? Is it democratic? Is it authoritarian? Could you just tell the Commission what kind of a CJ we would expect if you became one?
My choices are democratic? Or do I have any choice?
You have choices, just explain to us.
Okay. Thank you, Madam Chair. I will have to go back a little. Actually, not back, a little forward, which is where I was going. And permit me, with your kind permission, Madam Chair, I will answer that question by then talking about it was on account of my diligent handling of the Goldenberg cases on behalf of the public, meaning I was responsible or retained to try and recover the billions lost. Due to circumstances beyond my control, I left those briefs, and several years later, when there was a change of administration, I was selected without consulting me and appointed to become the Director of Public Prosecutions. Now, I will answer the question of leadership in the context of my role as the Director of Public Prosecutions. I was dragged kicking and screaming to the desk of Director of Public Prosecutions. And after I settled down to the fact that I had no choice but to once again serve the public, I had a leadership challenge. And this is how I explain my role and my qualities as a leader. I found a small, demoralized team of State Counsel / public prosecutors at the State Law Office who had absolutely no interest in what they were doing. They didn't care. They went to court. They went through the motions. They weren't proud of winning a case because nobody around them cared. And I come to something that has featured in some of the interviews I have watched. I had no money to offer them. I had no improved terms to offer them. They knew exactly what they required to perform. There is always a list in public service. When you ask a public servant what would he require to perform better, he'll tell you and he'll list down what he requires. When I looked at the appointing authority's expectation, which was the NARC government that had come on board or come to power on a platform of anti-corruption, the demand of me was that I sort it out immediately, get work done, and start prosecuting effectively. So my leadership style comes in. I have to talk to these demoralized colleagues of mine and, first of all, convince them that it is public duty, it is patriotism, it is a country they are serving. And in good time, which I promised was not going to be a very long time, there would be an improvement on their terms. I had support from the concerned agencies, all the way from the Treasury, from the Office of the President, and so on, that would come in due course. So my management style was one, first of all, leading from the front. Whatever it needed to be done, I would do it with my own hands. If it required me to go to court myself, I would do it. And many times when the cases were of a sensitive, in a serious nature, with a lot of pushback, even politically, and I would see the nervousness on the faces of my colleagues, my juniors, my reports, I would go to court myself and lead by example. I am therefore, I lead from the front, I am consultative, I am empathetic, and maybe I should give the Commission one of the real-life cases I had to handle. Shortly after I was appointed, I was interviewing for my department. And I had this young lady who said she wanted to work for the department, and she had lived for it. And I said, from your papers, from your interview, you qualify, but you seem to want to say something. And I said, what? And I asked her, what was it she had to say? And she said, I'm getting married shortly after this interview. And I will only take this job if you will assure me that I can go for my honeymoon. Because if I don't go for my honeymoon, I might lose my newly wedded husband. And I said, I give you my word that if you take the job, you will go for your honeymoon. I will not stop you. Even though you're not entitled to leave, I will ensure that you take some days. So she came on board, and within a few days, she wrote a memo asking for a few days off. And I said, I gave you my word. I will take responsibility, and I will explain your absence at the inductions that were looming. And I did put in a memo. She came back from her honeymoon, and after the month ended, or shortly after that, she got a memo telling her for failure to attend the induction, she would be punished. She would have to reimburse the government the entire amount that was used on her so-called for failure to attend. And she came back in tears, said, I now have to leave the government because I haven't earned anything, and I'm being told I will not earn anything for 2 months. And indeed, the end of that month, she got nothing. I took it up with the Attorney General. It became a crisis for the office because the entire office stood with her. And I took it up with my boss, the Attorney General, and I said, this is not right, this is not fair. And if I was at fault for having given her the permission, I would pay her salary. It took a push and pull, and finally her money was reimbursed, returned to her account, and it moved on. The office was replete with those examples where you just had to be human, just had to understand the problem. So at the end of the period, that I was there, which wasn't very long. I know I was that kind of leader. I kept everybody together. We performed miracles. The terms of service were not improved at the end of the first year for reasons that might be evident in some of the documents that I transmitted to the Commission. We were being frustrated by the accounting officer of the office. He didn't seek enhancement of our budget. But what I'm trying to say is I stayed with the team. I played with the team. And you're talking about leadership style. Despite numerous opportunities I had to travel and see the world and attend conferences, some important and some not important, I didn't think it was an important thing to do when you're in an important job in the public service. I stayed at home, traveled very little, and worked as hard as I could. So that's my leadership style.
Thank you. Thank you very much, Senior Counsel. I will now request the Honorable Acting CG to ask her questions. CJ, sorry.
Thank you. Senior Counsel, what would you consider to be the role of presiding judges and heads of station across the country what would you consider to be the main challenges they face? Because they are the decentralized leadership out there, and what solutions would Senior Counsel offer as Chief Justice?
Thank you very much. And Madam Chair, may I ask for the liberty of referring to everyone as Commissioner and then their name, to shorten the titles?
Yes, you can.
So, Commissioner Mwilu, thank you very much for the question. I appreciate it. And I am grateful that I was given the opportunity in the last few minutes to explain my role as the DPP. There weren't very many state counsel in the Department of Public Prosecution, so I give you a number, 50. Today there are hundreds. But in the context of your question, my role during the time I was DPP is identical in some shape or form to the responsibilities of a presiding judge. You are the head of a unit or a department or a group out in the provinces, and you are in charge of all matters that arise. You are in charge of ensuring their output. You are in charge of discipline at the first level, taking complaints and making inquiries. And you are in charge of ensuring they stay motivated. They stay motivated. And in your, the judiciary, and I should call it ours for the purposes of this interview, in the current state of that is, of course, ensure performance as far as the performance management outputs are concerned. Insofar as problems are concerned, the problems that I have described for the DPP are no different from the problems that existed at some point for presiding judges. But today's problems, to me, appear different. Today's problems indicate a situation where today, meaning there is no Chief Justice, and I say yesterday, and when I say yesterday, I mean it figuratively, perhaps in the tenure of the previous Chief Justice, I have discerned from a memoranda that was submitted by the KMJA that to some extent there was a bit of a disconnect between the administration of the immediate past Chief Justice and the presiding judges in some of the work they were doing. So my solution, if I were honored to be appointed the Chief Justice is to be a Chief Justice who, to use another description for leadership, a walk-around leadership style, where you spend a lot of time visiting your colleagues in the divisions, in the counties, in the magistrates' courts. I think I would spend far more time visiting them, listening to their problems, of course accompanied by the appropriate team of administrators, so that some of their problems are attended to as quickly as possible, because I think in many cases it's a question of communicating the problem and somebody responsible enough hearing the problem. That's my solution, Madam Commissioner.
Senior Counsel, did you say that the situation is different now because we do not have a Chief Justice?
I said, as long as it is not a Chief Justice, the chief situation may not change. And I am not saying that the acting Chief Justice is not doing her best. I am simply saying it is not the same as having a Chief Justice, because the Chief Justice ultimately is responsible. Anyone in an acting position does not really, is also acting for a temporary time. So you don't start anything that you can't finish.
Is it Senior Counsel's considered opinion that then for these last 4, now almost 5 months, there's been a vacuum in the judiciary?
It is not an opinion, it is a fact. There is no substantive Chief Justice in office.
No, the question is vacuum. Has there been a vacuum?
I have not done a survey to ascertain what it is that would be described as a vacuum. I will only say I go by what is current and available to me, and I go by what I have read very carefully in the memorandum of the KMJA. So they are not concerned, they're not dealing with your performance as an acting Chief Justice. They are talking about the past administration, and they are talking about what they hope for in a future administration of the office of the Chief Justice. So I wouldn't want to pass any judgment on your performance as acting Chief Justice for the last 4 months.
Let's close that particular discussion on asking about the limitations to the execution of duty of an acting Chief Justice.
I beg your pardon?
What are the limitations, if there are any, known to you about the execution of duty of an acting Chief Justice?
I think the law is quite clear, the Constitution is quite clear. The acting Chief Justice shall do as much as they can while awaiting the appointment of a substantive Chief Justice. So the limitations are found in the word acting. Acting. When I say acting, it means exactly what it is. When you run an institution and your term is based on awaiting the appointment of a substantive holder of the office, every single person in that office views you through a certain lens. You are temporary in that office. For example, if you took a decision that in some way affects them, there would be the expectation that if the process was not concluded by the time there was a new Chief Justice, that decision could be reviewed. So what I'm trying to say is, and it is meant with no disrespect to you in your performance, I'm talking about what I know to be the outlook of any public servant when dealing with an officer who is holding office in an acting capacity.
Thank you, Senior Counsel. Had you not raised that question, we wouldn't have discussed it. But the more substantial question is, in your considered opinion, what you think an acting anyone is limited from doing. I want to suggest that your view, which you are 100% entitled to, is yours. Mine is completely different, and I think the law abhors a vacuum. There cannot be a vacuum, and I am not aware that the acts of an acting director, Chief Justice, would be reviewed on account of having been executed during the period of acting. But let's go to more substantial things. And the next one is this. This institution is run, at least since 2011, on certain systems with certain leadership positions and management tools that help the institution to achieve its core mandate, which is to make access to justice available to all Kenyans. Please tell us some of those systems that are already in place in the institution and how Senior Counsel, as Chief Justice, would either enhance or strengthen them, or what alternatives Senior Counsel Chief Justice Murgor would employ.
If I became Chief Justice?
If you became Chief Justice.
Thank you. I start, first of all, by recognizing the great work that has been done in transformation. It's unimaginable. As I explained earlier, I was there at the beginning. Perhaps I was interacting with the judiciary long before many in this room. So I know the wonderful work that has been done in the area of transformation. And I take this opportunity to salute Chief Justice Emeritus Willie Mutunga in that regard. Well, first of all, on his vision. It's truly revolutionary. I also congratulate immediate past retired Chief Justice Maraga for the work he did in sustaining some of those transformation measures. So, and maybe I should go on to say, and the entire team of existing judicial officers who today, Madam and Commissioner Mwilu, are led by you. Plenty has been done. Plenty has been done. Now, you ask me what I would do to improve it.
The first part of the question is the systems already in place, and then what you would do as Chief Justice to either improve the existing systems or your own systems that you as my Lord Chief Justice would then develop.
I am going on, and I was developing it, what I would do, and I need to then identify what is the problem that it would then require me to do anything. In an ideal and optimum situation, which is what it is not, if I were to have come in such a situation, I would simply ride on the train and let the systems run themselves. But the situation is not optimum. The situation is not ideal. There is a huge challenge. There is a huge challenge. For example, on the issue of capacity, which affects access to justice, it is greatly affected by the staffing issue. The staffing issue, and in particular, I'm not talking about the 40, 50% to bring up the judiciary staff to 9,000. I'm talking about the judges that need to be appointed. And then I'm talking about the funding issues, which would then enable rollouts of ICT and everything else, and recruitment. That is the challenge. So I'm not coming into a situation or a job in order to carry on and improve. I'm talking about a situation where the ship of the, if I may liken it to a ship, merely, a ship of, that is the judiciary, which is a huge organization now, far larger than it ever was, is slowing down. It's grinding to some sort of halt. So it's not a question of improving, it's a question of what can I do, or what will I do to ensure that the system doesn't stop altogether. I was thinking about this problem, and I likened the problem facing the judiciary to the recent massive container ship that got stuck in the Suez Canal. It was called Ever Given. Modern ship, the best captain, obviously, all the technology in the world, sailing down the Suez Canal, and somehow something went wrong, something small. Lost control, the ship turned to one side and got stuck in the canal. It caused a huge pile-up of traffic on both sides, a slowdown in world trade. For those who had to go around the Cape in South Africa, higher costs, slower delivery of services. From where I sit as an advocate, I can see that for the last 1 year, there has been a slowdown in the delivery of services to the public. And that problem has featured in every conversation for the last 1 year. It is on account of the failure to appoint a certain number of judges, cutback in budget. And Madam Commissioner Mwilu, please permit me now to explain what I would do. I consider those two as the causes of that slowdown. I consider that as the thing that, or the issue that has to be dealt with as a priority by any incoming Chief Justice. I sit here on this chair today in the firm belief that it is unlikely that anyone in the ship that is called the judiciary can get the ship to move on. Like the ship in the Suez Canal, the captain must have tried what we all do when we get stuck in mud, engaging first gear and reverse backwards and forwards and hoping to get out. But it was obvious after a very short space of time that the only people, or the only intervention that could resolve the issue of the ship in the Suez Canal was external intervention. There had to be tugboats on the outside, there had to be excavation on one side or both sides, and finally the ship got going. I bring that analogy to the issue of the judiciary. For 1 year, the administration of the judiciary, and forgive me for saying this from where I sit, which is not 100% informed, I include the JSC in it, have, whatever means they've tried to engage, has not resolved the problem that has led to the crisis in the judiciary. There could be many reasons. I could hazard some of them. My personal view that the Honorable, the retired Chief Justice, speaking on the steps a few meters away from here to everyone concerned might not have been the best solution. But whatever it is, it didn't work. And one of the questions I would love to ask.
Counsel,
yes.
Senior Counsel.
Yes, madam.
That is, to you, only one aspect of our failure, according to you, to deliver optimally for the last 1 year. I was asking for the systems inside, but so that we can make progress, I shall just mention that we have systems in here that are called LMTs, Leadership Management Teams. We have the CUCs. We have the JLAC, which is the topmost governing body that assists my Lord the CJ to deliver. But while still on that topic, and so that we can get out something that we are looking for, let me ask the next question, which is part of the roles of the Chief Justice. There are many of those. We will not ask a simplistic question there, but let me mention this, that one of the roles, Senior Counsel, you will have to perform, if God grants that you'll be the next Chief Justice of the Republic, is to make rules and regulations as mandated by a number of statutes. From the background of legal practice, and knowing as I do that you are forever in these courts, please tell us the challenges you have faced will lead you to regulating, making what rules for the effective enabling the institution of the judiciary to effectively make it possible for Kenyans to access justice and for the legal practice to effortlessly earn their keep.
Madam Commissioner, first of all, perhaps you will allow me to finish my answer. Because it also dovetails into exactly what you are asking me. So the problems of the judiciary today that require outside intervention is, in simple terms, a different approach. As the old saying goes, when you're in a hole, stop digging. The other saying goes, don't do something in the same way all the time, months in, months out, and hope for a different result. So, solve the problem of capacity, the appointment of judges, solve the problem of the funding, and the ship will continue moving, justice will continue flowing, and who knows, you don't need outsiders like us coming to tell you what to do. As for the rules and rules made by the Chief Justice, there is absolutely nothing wrong with the existing rules, and where necessary, the relevant committees will look at them, having taken feedback from all other affected agencies, court users, bar bench, and those are framed and finally promulgated following an agreement and consensus on what is required. So I personally, as a practitioner, have no problem with rules at all.
Thank you, Counsel. Thank you, Senior Counsel. Let's go to a different area now that I have to cover within the time given to me. which is this. Council, listen to this. Senior counsel, listen to what I'm just about to read. Judicial power to nullify a law duly passed by the representative process is a restriction upon the power of the majority to govern the country. And I'll take that again. Judicial power to nullify a law duly passed by the representative process is a restriction upon the power of the majority to govern the country. Briefly and with guided answers, would counsel kindly discuss that?
That really is the power of judicial review. And that power exists in our courts. And I'm not sure there is anything more I can say to that. The courts have the power to review some executive actions. In addition to that, the courts have power to declare certain legislation unconstitutional, declare certain actions by the executive unconstitutional.
All right.
And it is in itself, as you say in your question, the power to check the excess of those who at a certain point of time might be in the majority. So it protects the rights of minorities and those who may not have the power to legislate for their protection.
Thank you, Senior Counsel. In your opinion, is there a contradiction between the mandate of the institution of the judiciary under the constitutional framework and the principles of judicial restraint?
Please come again.
I'll take it again. In your opinion, Senior Counsel, is there a contradiction between the mandate of the judiciary under our constitutional framework and the principles of judicial restraint?
I'm not sure that I quite get your question. A contradiction between the judiciary and the principles of judicial...
We are told that the Constitution has told us what we must do.
We are told that the Constitution...
The Constitution itself has told us,
yes,
has given us our roles in Chapter 10.
Yes.
Out there, then we are told, and therefore the judiciary must continue to discharge its duties to the best of its knowledge and ability under Chapter 10 of the Constitution. You will hear that the judiciary must exercise restraint. In fact, if I left it there and I said discuss, what would Senior Counsel say?
You know, you make it sound, Commissioner Mwelo, like we are in an exam. But my answer, my short answer, is, and I suppose we are, or you are alluding to the subject of judicial activism and its limits, or what are its perceived limits, whether it is desirable or not. But my short answer is this. I don't know who has told you when you say we are told, but I'll take it that that is a criticism that has been leveled at the judiciary by some quarters. For my part...
Senior Counsel, if you live in this country, you have heard those statements all the time. That the judiciary is doing things that are not theirs, they should not annul laws, they must not... Remember, we are covering a certain topic. They must not legislate from the bar, they must from the bench, etc. There must not be activists, they must exercise restraint. That is as simple as I can make it, Senior Counsel.
You know, perhaps I'll answer it by answering a question that I had expected Madam Chair to ask me as I started. What is my judicial philosophy? Then that way I will give you an answer that stands in a certain position.
That is the topic that we are covering right now. That actually is my area.
Madam, I will answer your question in the way that I see fit. So okay. Please give me a bit of time. So I believe there are two philosophies on either side of a spectrum. There is the progressive and there is the conservative, and then in the middle there is what I would call the moderate philosophy. I belong to the moderate philosophy. So in answer to your question, too much of either side is not good. Too much conservatism, too much progressive interpretation is not good. In the positive spectrum, a judge supplants his personal, political, or other views on his interpretation of the law, and you get a situation where you start at point A and you end up so far away that when you look at the section or the article that is under consideration, you can't recognize it. So, to the phrase, there should be judicial restraint, I subscribe, in the sense that one must limit themselves to the limits provided under the Constitution. Now, when you look at our Constitution, as it has been described, it is very progressive. And if it is progressive, many of the articles allow for a purposive, for example, a purposive interpretation. It gives the judge some leeway in interpreting that section. The phrase or the criticism that you refer to as judicial restraint is simply a comment that can be made by a party that feels aggrieved by that decision, that even as you interpret an article, you should exercise judicial restraint. You can go so far, but don't go too far. So that is my short answer.
Senior Counsel, I thank you. Let us go still under the same topic to the Constitution. Emeritus Chief Justice Mutunga once said this, which I quote, "It is unusual for a constitution to be as preoccupied by the question, scope, methodology of its own interpretation as Kenya's 2010 Constitution." I'll read that again. "It is unusual for a constitution to be as preoccupied by the question, scope, methodology of its own interpretation as Kenya's 2010 Constitution." Now, Senior Counsel, as our interactions, I hope I should have actually started there, with the Supreme Court's decisions, particularly those concerned with constitutional interpretation. And now this is a question. What are your views on the court's position, the Supreme Court's position, on constitutional interpretation? The second limb of the question, distinguish for us, please, what you consider to be the methods and objectives of constitutional interpretation, and whether it is possible to generate progressive and contextual jurisprudence utilizing the tools of strict constitutional interpretation. Are we still together?
You've lost me. I'm not sure even you are with the question.
Yes, I am.
Please repeat it.
I am with the question because I'm the person asking the question. It took me time to come up with the question.
Okay.
So I know the question. And it is this. And it exercised the mind of Chief Justice Mutunga as it exercises mine today, and as it has exercised the minds of many counsel in this country when they discuss the work of the Supreme Court. Chief Justice Mutunga was of the view that the 2010 Constitution was so subjected to discussion as to its scope, the methodology of explaining itself, explaining as into interpreting it. And so I ask, part of the criticism the court has received is that it does not know what it does when it is interpreting the Constitution. And here we are looking for your views
as to whether or not they know what they're doing.
That, and whether or not there's a difference between, there are many ways of interpreting the Constitution as the Supreme Court currently, as constituted, understood its role, and as any interpretation it has applied to the Constitution been restrictive to creating jurisprudence. I hope now you understand.
I will try and answer your question as I understand it. I first deal with the Constitution. There are those who have studied the type of Constitution we have, and as much as it is described as the most progressive Constitution and the best Constitution on the continent or in the world, there are many who are prepared to concede that in being so elaborate in scope and methodology, and even in trying to interpret itself, it lends itself to very many interpretations, so that those who achieve what they want through certain interpretations of the Constitution are happy with it, and those who feel aggrieved by that interpretation are not happy with it. In the early days, when the Constitution was first promulgated, these comments, there were many discussions about what else it could have been. And I was one of the individuals who thought the same Constitution could have been concised into a statement of principles, like, for example, the United States, rather than one that seeks to almost be legislative in nature, to provide for every single situation, so that when it does not, it creates a problem. When it provides something and it overextends itself in both scope and methodology, it creates a different problem. The problem that you are now referring to is how the judges in the Supreme Court themselves understand it. And it may explain why they have come under some criticism. But I have, as much as I have been before the Supreme Court, I have not worn the shoe of the judge who has had to make these determinations in various matters. So I will not pretend that I can criticize them, I can second guess them, because while I read the decisions that come out of that court, I don't read all the arguments that are presented to them. So I would request that it be permitted to be the extent of my answer.
Thank you. Thank you, Senior Counsel. This is the second last question I ask. If God grants that you be the Chief Justice, you will require to be the team leader in the policies of the judiciary. Please discuss with some emphasis on some of the key policies that we have adopted in the 2019 to 2023 Judiciary Strategic Plan. as the role of the Chief Justice there. Then I'll ask you the final question on the Supreme Court as President, and that will be my last one.
I would request that you ask the question once again.
As Chief Justice, you would be the team leader in developing policies that ease the way we do work here and to enable us to achieve our core mandate, the reason for which the judiciary was established. And so the question is, with a bit of emphasis on access to justice, please discuss a few of the policy issues that we have discussed in our 2019-2023 strategic plan.
I'm sorry, madam. Your question is not specific enough for me to answer it. Maybe I should put it this way.
Have you interacted with the 2019-2023?
I have it here.
Good.
But what I would like to say is this. I don't fault anything that you have done so far. The wheel has already been invented. So my job, as I come in, as you say, if God wills it, is to make sure it works.
Senior Counsel, yes. We are testing as a commission. You are having interacted with the policy and understood what it is we think will enhance access to justice between 2019 and 2023. We are not asking for a critique. We are trying to get to know that you have interested yourself sufficiently in the workings of the judiciary to see its strength, to see its weaknesses, to see what you are coming to fix. And so the specific question is, on what we have seen as our strategic priorities for the period 2019-2023, that we have already put those already. The work is done for you, for us as a commission, and for us to be able to assess you. It is to see what you have taken out of that and what you would do differently if you came in as Chief Justice.
I'm trying to make my answer simple. I would do nothing differently. I would make sure it happens. I would provide the necessary leadership for the judiciary to implement what is otherwise an excellent strategic plan.
All right.
Yes.
Give us the specifics of the strategic plan that you consider excellent towards access to justice.
I'll deal with one. Let us deal with the question of access to justice by way of enhancing technology. Technology, in my view, is the way out of most of the problems facing access to justice.
Sorry, are you still ongoing?
Yes.
Yes, then finish that.
I see a situation, and I have read all the documents prepared by the judiciary. I have seen how access to justice has been dealt with regard to the people, with regard to the culture, with regard to the physical facilities, with regard to manpower. When I say people, I mean manpower. And I see, in the light of all the challenges that the country is facing today, a lot of rationalization needs to be done. You need to relook at the planning aspects of all the development projects and rationalize them so that rather than having 62 courts that are incomplete, rather than having ICT projects that are in the pilot stage, stuck in a few courts, rationalize them so that you are able to complete a few projects. And the one that has the biggest impact on access to justice, on the delivery of the core mandate, which is justice, is developing rolling out, fully covering the country with ICT capability in every respect, from end to end.
All right.
Yes. So
The
if you
Supreme
tell me
Court-
to run with something, I would run with that.
All right. Thank you, Senior Counsel. I said my final question will be on the court at which you would be president if God were to grant that you be the Chief Justice. That court has had occasion to deal with certain cases, a number of them, to enable our initial vision of being the court that has promoted alternative dispute resolution mechanisms. Would you like to discuss one or two of those cases and tell us what the decisions were?
The decision that has
Enhanced alternative dispute resolution mechanisms, or even discussed the issue of alternative dispute resolution.
the one that comes to my mind is U2? The one that under discussion is the one that
I could actually mention two of them.
Yes.
One is Synergy, a famous case, and the other one is New2.
Yes.
There is a line of them there. But could you then tell us, those two, what was their import? What were they concerned about? How have they helped us to be better at promoting alternative dispute resolutions?
U2's decision is the one I had in mind. And I'm grateful you ask, because I am also an arbitrator, and I also undertake and also conduct arbitrations. It was quite disturbing in the manner that the string of decisions had gone to create a situation where there was no longer any certainty about finality of arbitration decisions. So U2 put that back in good stead, that the whole idea, not U2 actually, it's, I actually should say that I'm in agreement with the decision of the retired Chief Justice, that there should be a finality in the decisions.
In New2?
No, it's the other one.
No, it wasn't New2, but thank you very much, Senior Counsel. That will be the end of our discussion, and I wish you well.
Thank you very much.
Thank you, Chair. Sorry, thank you, Chair.
Thank you, Commissioner Acting CJ. I would like to now ask Honorable Commissioner Judge Wasame to ask his questions.
Okay. Senior Counsel, once again, welcome.
Thank you.
You talked about the principle of judicial restraint, which is to allow the legislator and the executive more freedom to formulate laws and policies. How will you align that with judicial activism or adventurous tendencies by the courts, especially in the court where you intend to be the president?
I did mention, Commissioner Warsame, that I don't subscribe to extreme judicial activism. And at the same time, I don't subscribe to total restraint and conservative interpretation of the Constitution. I subscribe to the philosophy whereby, where it is clear there is room for purposive interpretation, then a court is required to and should proceed along the path of interpreting the article in question in order to make, in fact, they say the purposive is in order to give effect to whatever the Constitution was trying to provide for.
Now, you are a criminal lawyer, of course, being the DPP.
I practice criminal law.
Yes.
I'm not a criminal lawyer.
Yes. Thank you for the correction. You have read maybe the Moriotetu case,
Yes.
which said at Section 204 of the Penal Code insofar as it provides for a mandatory sentence. Death sentence is unconstitutional. And the court said, gave some direction that the Attorney General, the DPP, the Speaker of the National Assembly and the Senate to do certain things. Would you consider that decision to be an aggression on the part of Parliament and the people of Kenya? Because the Penal Code under 204, as read together with 203, 296(2) of the Penal Code, the one which deals with robbery with violence, and treason. Those are capital, they provide for capital punishment. Under the Constitution, which our Constitution, you termed it as progressive, Article 26, I think so, either 26 or 25, provides for death penalty, provided it is prescribed under the law. What is your view?
About Murwatetu or about what the Attorney General was required to do?
The Murwatetu case.
I have no qualms or problems with the final result in the Murwatetu case. I think it is sound reasoning.
In terms of its import.
Yes.
And how it has been misused to even provide for other offenses, like the Sexual Offences Act, and for example, 2962. What is your view?
Now, my Lord, with your permission, and I will not name names, but you and I might know what we're talking about. There was once a case where there was a fight and it resulted in a death, and there were two individuals involved. One pulled the trigger, one might have been involved in an earlier altercation. And I recall in that decision, the judge said, since somehow these two issues are connected, without the fight, the subsequent pulling of the trigger would not have occurred. I find both of them, the judge found both of them guilty. Now, Murwatetu specifically dealt with that kind of case. The culpability, the responsibility of both actors is completely different. When the first gentleman was having his verbal altercation, he could not have imagined that it would have ended up with his friend doing something, pulling a gun and pulling a trigger. So to that extent, I understand the persuasive reasoning of the Supreme Court in that regard, where there should be qualification, there should be scope for determining, for punishing responsibility by way of the sentence to be meted out. When the second part of it, or the other part of that, when you mentioned it, when the court requests that the matters be placed before the Attorney General to consider legislation, amendment of the legislation, I also have no quarrel with that. Now, I'm coming to other types of acts. I think every act should be looked at on its own and what it is intended to do. The case of murder, it was simply a case of the old teachings in several holy books. Eye for an eye, you kill, you are killed. But over time, that qualification is being made by society. The death penalty is being abolished and so on. So there's a movement in a certain direction. But in the case of other statutes, I may have some reservation. For example, I didn't mention it, Madam Chair. I have been involved in wildlife conservation, in particular, the fight against trying to stop poaching of elephants. Some years ago, I was the chairman of a group that very successfully agitated and ensured that was done. And in the course of all that, we dealt with the levels of involvement in handling game trophies. So that if you are found with so much, you are deemed to be this and deemed to be that. And the only way that it could actually be a deterrent is, and we're now not talking about murder, which sometimes is simply a crime of passion, and it's a series of events that end up in death. When you are dealing with things like narcotics, when you are dealing with things like game trophies, the message that the legislator wanted to send out is, if you handle an elephant tusk in a certain way, you are guilty of a certain offense which provides for a minimum. So there is where I personally would find some difficulty. So I would prefer, if there's any question regarding a particular statute, I'll express myself.
Okay. Under Article 143 of the Constitution, the President of the Republic of Kenya enjoys immunity both from criminal and civil cases during his tenure. In one of the decisions in the Olekewa case, we said, if the president decides to sack, for example, 20 judges on the same day without following the correct procedure, he does not enjoy immunity or protection. What is your view in terms of criminal prosecution or civil prosecution of a sitting president in terms of the article? What does the article talk about? Actual things which the article is talking about. In your interpretation as the president of the Supreme Court, CJ Murgor.
Now, my Lord, I see a situation arising.
And you have the option not to answer. You can say pass.
I know I want to answer it by not answering. In this way, when you put forward a hypothetical situation like that, I think it's unfair to a person who you consider may end up in the Supreme Court. Because should he be faced with such a situation, he would have already expressed his view. And it would be the first order of business to disqualify that judge. So these hypothetical situations have their examples that are posed as questions have their dangers. So I would request that it is...
Can the president sue personally? I'm leading to other questions which will come. During his period as president of the Republic of Kenya, can he sue personally?
I think by the same vein, you know, that's exactly the same situation is arising. You know, if he were to sue personally, if the question arose as to whether he can, it would be a justiciable issue which would end up coming up to the courts. So I would prefer not to also express my view.
And I want you to express your view. Does the deputy president enjoy the same immunity under 143?
Again.
And I want your view. I want you to answer, because if the reason why we are here, we want you to know your views. We are not saying there is anything wrong with expressing your views.
There is absolutely everything wrong in expressing a view about a matter that may become a reality in due course, for whatever reason, or not a reality. If I was interviewing for Director of Public Prosecutions, I might have answered your question. But I am not interviewing for the Director of Public Prosecutions.
Okay.
I am now going to sit as a judge. I have no view that is worth putting out, because I must be seen to have a blank mind when I will hear anyone in such a dispute, on such a question.
Senior counsel, I'm a judge. I was involved in the Olekewa case, and I expressed my view. You can sue the president if there is a clear and dire constitutional violations in his personal name.
How did you express your view, my lord?
In the Olekewa case.
As a judge?
As a judge.
And I assure you, when that question comes before me, and I am a judge, I will express my view.
Okay.
Yes.
Now, under Article 144 and 145, the president can be removed on grounds of incapacity.
Yes. Yes.
Under Article 147, one of the functions of the Deputy President is to act as a president when the president is temporarily incapacitated. If there is a conflict and the Deputy President says, you want to start 144, but I am the Deputy President of the Republic of Kenya. Therefore, 144 cannot kick in during my term. How will you rule?
How can I tell you how I will rule? You might make me the Chief Justice. How can I tell you how I will rule in advance?
Okay.
If you were confronted with the same Olekeiwa decision before you had ruled, would you have told the whole world what you would have done?
You see, you are on that chair, and you are the one who is seeking to be the president.
My Lord, I request your pardon.
Okay. I have no problem.
I am saying
I have no problem.
I am saying the question is, as I have asked it by way of asking a question.
Yes.
I've answered it by way of asking a question.
Okay. Under Article 144 and 145, which involves the removal of the president. If the president is removed under one of those articles, is he entitled to approach the Supreme Court? And how will you deal with that case? And that's why I was asking you the immunity of the president under 143. Because this one is his personal, because he's removed as the president of the Republic of Kenya under 144 and 145. Can he now approach the Supreme Court in his personal name, or the decision of the tribunal and the parliament and the Senate is final, according to you?
My Lord, you are asking me to express a view on jurisdiction.
Okay.
If I would...
Let's go to the next question.
Yes, I can't.
Yes. Article 146(2)(b) provides in the event of a vacancy in the office of the president, the DP takes the office. In the event the DP is not available, the Speaker of the National Assembly. But the Constitution is silent. In the event the Speaker of the National Assembly is not available, who will be our president?
My Lord, on a light note, I was reading it, I saw the gap, and I said to myself, it might be the Chief Justice. And in the absence of the Chief Justice, it would be the Deputy Chief Justice. And in the absence of the Deputy Chief Justice, the senior most... What am I saying? I cannot speculate. It says what it is. If it is a matter that there is a gap in the law...
Senior counsel, you are right. Because the first stop is the legislature. The third stop is the judiciary.
Yes, but those who drew up this constitution, those who are framing the laws now, those involved in amending the laws right now, those are the things they consider. The Chief Justice, the judge of the Court of Appeal, like you, the judges of the Supreme Court cannot go into that arena where they are filling in gaps in such a substantive manner.
Okay, and this is my last question. The question of review of punishment, of sentence, conditional pardon, substituting sentence is ordinarily reserved for the judiciary. Ordinarily reserved for the judiciary. Tell us one instance where the President of the Republic of Kenya can exercise judicial function.
In our law, it provides for presidential pardon.
Tell us one instance where our president can exercise judicial function as a sitting president.
I see what you're asking. You're saying he seems to be performing the judiciary function. Where do we perform?
I didn't say judiciary function, I said judicial function.
You have asked a question where you said, show me one
I said, tell us one instance where our president, the President of the Republic of Kenya, as a sitting head of the executive and the government, is allowed under the Constitution to exercise judicial function.
He doesn't exercise a judicial function. He just exercises his presidential powers.
I wish you well.
Thank you.
Under 33, Article 133, it's a judicial function. Thank you very much. I wish you well.
Thank you very much, Judge Wasame. Thank you, Senior Counsel. It's now the turn of Honorable Commissioner Justice Majaja to ask his question.
Thank you very much, Chair. Good morning, Senior Counsel. You presented 5 sample writings for consideration by the Commission. The first one, submissions in a case you argued.
If I may just, pardon me. Please permit me, Commissioner Wasame. Madam Chair.
Yes, sir. Senior Counsel.
He put article of the Constitution on the table and then said, thank you very much. In fairness to me, I am looking at the article. At no point whatsoever under Article 133(1) is the President said to be exercising a judicial function. It might be his respectful view, but it is not worded so in the relevant article. Thank you.
Judge Wasame, do you want to respond or it's okay? Thank you. Thank you, Judge. Noted, Senior Counsel. Go ahead, Judge Majaja.
Thank you, Chair. Yes, Senior Counsel. Yes, you presented 5 written samples of your writing. The first one is submission in a case, Laser Isle Center Limited versus PBM Limited. This was a landlord and tenant case. Unfortunately, I believe one of my fellow commissioners is cancelled in that matter, so I will not pursue that particular case. The second one is an arbitration. You did, and you told us, actually, there are 3 very important cases the Supreme Court has decided on this issue. Can you please tell us which cases are these?
Which ones?
I am asking, in the line of arbitration, there are 3 important cases the Supreme Court has decided. 3 important cases.
The one I'm aware of is the Newt one.
Yes, the Newt one. And then the other one?
I said that's the one I'm aware of.
Yes.
That comes to my mind.
You are aware of the Synergy?
No, not quite.
Are you aware of Geochem and Kenya Bureau of Standards?
No.
Okay. Because the Bangalore Principles, which, you know the Bangalore Principles, there is a principle on diligence and competence, isn't it? What does that mean to you, diligence and competence?
Both the ability to understand the law, to write the law, and to deliver on time.
Deliver on time. And one of the aspects which, as Chief Justice, when the magistrates will be coming here, is the duty to keep up with the latest decisions of the Supreme Court. You know, Supreme Court is the Supreme Court, and part of its jurisdiction is to give precedents that are binding on all courts. So that's why I'm asking if there are 3 important decisions on arbitration. It's something somebody should know. But that said, what is the ratio of those 3 decisions? What exactly is the ratio of those decisions vis-a-vis the law of arbitration?
There should be finality.
In what way? What is the ratio? That there should be finality?
In the sense that after the arbitrator has rendered the award, with exceptional circumstances, there can be an appeal to the High Court, but after that, it is final.
Okay, I'll leave that. Then you have, there's another written piece here on Murgor developers. These are matters which I presided over, so I will not deal with it. And then we have submissions in Rose Wangui Mambo. This is submissions in reference to a taxation. I dealt with the primary issue, the issue concerned costs. I will not deal with it. And finally, submissions in Samuel Muhia, Kariuki, and others. This is about pyramid schemes. Is this matter complete yet?
No, I believe it is on appeal.
It is on appeal,
yeah.
So I will not touch it. So you've given us these sample writings, which you have made it very difficult for us to pursue, isn't it?
Well, I didn't do that deliberately. It was all done in a bit of a hurry. But I should say, my lord, and with great respect, that I understand sample writings to be more a question of determining whether somebody
yes.
can write in English and communicate more than what his thinking is and what is, because that is a question you can ask directly.
And the questions I can ask now, if I ask you about this case, I will be influencing whoever will determine those cases, you see.
So it wasn't deliberate.
Okay. So there is something we call horizontal and vertical application of the Bill of Rights. Can you tell us what that means and whether you think it's important, that distinction between horizontal and vertical?
I think you'll have to explain your question.
No, my question is horizontal application of human rights and vertical application. That is the principle.
My understanding is that human rights are not only inalienable, but they are the one thing in the Constitution that must be observed by everyone, all institutions, and in particular the judiciary. So whichever way you look at it, either horizontally or vertically, it is something that is paramount.
Okay, let me go to a hypothetical, and you may or may not answer me. Peter and Mary are married. Okay?
Yes.
They have a child. In fact, they have 3 children. Peter took out a mortgage with a bank. But because of COVID, he is not able to maintain payments. He's lost his job. That has caused problems in the house. They have had a dispute. They've gone to the children's court because of that dispute. The children's court has said, okay, Peter, you move out, let Mary stay in the house. The bank is on Peter's neck. They issue a statutory notice and they advertise the property for sale. Mary goes to court and says, look, I have a right for housing. First of all, I have a right for shelter for the children. Then I have a right to housing. And I want an injunction restraining the bank. Given the nature of the rights, is it a case where the court would consider giving an injunction, and why?
That is an interesting hypothetical situation, because the bank has its rights. The individual, the couple have their rights. The child has some rights also to shelter and protection. To my mind, it would be wrong for a court to give an injunction against the bank. On the face of it and on the plain reading of the documentation.
Okay, let's put it this way. Mary is saying, I have a right to housing against the bank. It is there in the Constitution. Give me an injunction. So what is your answer in respect of the right to housing in respect of the bank?
No, Mary doesn't have a right to housing vis-a-vis the bank.
Why?
Because of the commercial nature of the bank's relationship vis-a-vis that property.
But
you didn't say whether the lady wife signed on the mortgage and was fully aware of the mortgage, because
let me put it this way: does the right to housing depend on whether you have a mortgage or not?
Yes.
Does the right in Mitubel? What was the issue in Mitubel, for example?
The Mitubel was one of these more contentious cases where the High Court went on an interpretation that went into the intendment of the Constitution. And I saw the reasoning of Her Ladyship Justice Ngugi putting some responsibilities on the government to provide for the families, for the wives, for the children, notwithstanding the fact the people on that land had no right to be on that land.
So what did the Supreme Court say?
In the Court of Appeal, and the Supreme Court subsequently stated that they couldn't help those people, except directed in the case of the Supreme Court that the parties could go back to the High Court and argue their rights on account of the breach of the court order. There was a court order at the point when the respondents leveled the informal settlement.
Okay.
So it's at large. It's in the light of that, one would say that the Supreme Court did not recognize those rights.
Did not recognize the right to housing?
It recognized the rights to housing, but not in that context, and not in the manner that they had argued it. Yes,
Also,
it said there is a right to housing.
I want to understand that right to housing. How did it recognize? Or you are now the Supreme Court. How would you recognize the right to housing, either for mother and child in that situation, or for the people in Mitubel?
In Mitubel, I think the situation is a little distinguishable in the sense that it was government land, and the position taken by the Supreme Court is that the government ought to come up with policies on what it will do when it evicts people on government land, which they should be sensitive to where they go and so on. In the case of the mortgage, that arena is one where the Constitutional Court would hesitate, or I'm even saying the Commercial Court would hesitate to enter. If the bank has outstanding money and it wants to realize its security, I would suggest respectfully that the best that a court of equity would do was perhaps hold the position, and that means giving an injunction and allow a small period of court-appointed mediation where the rights of the lady and the children can be catered for without a situation where the bank simply goes in. And because the man has an obligation to maintain his family.
And does the bank have a duty in respect of the right to housing?
No.
Okay. There's something called the doctrine of avoidance. What do you understand by that doctrine?
In which respect? In the same case?
In terms of you being the Supreme Court, adjudicating on issues, and there's a doctrine, just like the doctrine of mootness, there's a doctrine of avoidance.
Well,
no, I want you to tell me, because it's common.
Of avoiding tackling an issue.
Yes.
Yes. But it's self-explanatory.
Yes. Okay.
Yeah.
Why is the doctrine of avoidance? The doctrine of avoidance is about avoiding certain issues. Why is it important in the growth of jurisprudence? Why is it that a court can take a stance of avoidance in order to develop the law?
It all depends. I think it comes back to a question I was asked earlier about judicial activism, and in fact it was touched upon in the Murgor case, where one of the parties, I don't recall, I think it was one of the civil society parties, started asking for more and more orders in the course of arguments, and the court said on certain issues it had not been properly argued, had not been responded to as it should have been, and it invited the parties to deal with it in a different forum another day. So why is it important? I think it is important because at all times the court should seize itself of matters that are properly before it, rather than go wandering off in search of issues to resolve and make determinations upon. Otherwise, you use the term, it becomes per incurium.
Yes, but what I was asking is, how does that contribute to the growth of jurisprudence?
It doesn't. Jurisprudence will grow by itself. It doesn't have to be grow at a Super 8 by every judicial officer looking for issues to make determinations upon.
You mentioned the case of Murgor, and you also referred to the case in which you were involved in. the one of Dixon Mwangi, isn't it? Dixon Mwangi Munene. That's the word you were talking with my colleague commissioner. One, in Murwatetu, what was the ratio of the Murwatetu case?
The ratio in the Supreme Court?
Yes, the Supreme Court decision.
The ratio was that the judicial officer properly seized of a matter should have discretion in determining the extent of a sentence based on circumstances.
And how did the court reach that conclusion?
By looking at the fact that in the circumstances of Murwatetu and all other circumstances similar, once a judge had found that a person was guilty of murder, as the case may be, they had no discretion save to sentence.
But what was the principle drawing from the Constitution that the court was saying?
It ought to have discretion.
Yes. What was the basis of that principle? What is the basis of that finding? Okay. So you talked about Dixon Mwangi Munene, and the issue you were talking about basically is common intention, isn't it? That you were the one probably who was out there waiting with the car, and the person came and you went with him, or you're the one who brought him with the knives, gave him, and something to that effect. How does Murwatetu deal with common intention? Because that was the issue that was in the Court of Appeal, isn't it?
Yes.
Whether this is the principal actor and this is. So how does Murwatetu deal with the common intention? Or how does it affect common intention? Does it deal with the doctrine of common intention?
It requires a court to deal with and consider the question of common intention.
Yeah.
So it doesn't go into it in those circumstances, but it deals with the principle.
Okay.
Different facts, different considerations lead to different sentences, should lead to different sentences.
Okay. A major part of your work in the Supreme Court will deal with the election petitions. And one of the issues that will be critical is the issue of the burden of proof in election petitions. So, two questions. What is the burden, the standard of proof, in the law in Kenya, and why, how do you justify that standard of proof?
What is the burden of proof in election
The standard
petition?
of proof in election petitions in Kenya?
It is on a balance of probabilities.
Are you sure? Okay. Then we'll move to the final issue, and this is now to what you told in answer to the questions my colleague, the chair, asked you. You agree with me that, as you have ably said, the history of a man or a woman, the experiences are what mold you, isn't it? And you and I have some common history somewhere. We went to a very good school somewhere, and that has molded us in a sense, isn't it?
Absolutely.
Yes, the Hill School in Eldoret. So we have a common history there. So you talked about your experience in university, which that was in 1982. And I think for Kenyans, that period is very, it's one of the turbulent times in Kenya, where many things happened, and some of them well documented, some not so well documented. And then you went to the state law office, correct?
Yes.
So you were in the state law office until 1992. Am I correct?
Yes, you're correct.
Okay. So you recall that you prosecuted a case of George Anyona,
Yes.
Edward Oyugi,
Yes.
Ngodho Kariuki,
Yes.
and Augustus Kathangu.
Yes.
You were the prosecutor.
Yes.
And maybe I may not get the facts right, but please correct me, because these matters appear to have been scrubbed off the internet and other sources. So these men were arrested having certain documents at Mutugi Bar in Dagoretti Corner. Am I correct?
those were the facts.
11th of July 1990.
I don't remember the date, but go ahead.
Yes, and they were brought to court, and the trial began. They were not given bail, correct?
Yeah, possibly.
Possibly.
Yes, I'm waiting for the question.
No. I want us to lay the factual basis because
it's a long time. I wish I had
yes,
noticed.
It's a long time. But as I said, these are pivotal part of our history, and I think we must get it right. That's why I'm putting it to you, because you are the prosecutor. So if you don't know, you don't know. But I'm just putting them on record so that we are very clear. So they were denied bail. They were not given bail for sedition. And they were arrested in July 1990, and the trial began on 10th January 1991. Now, the four of them alleged that they were tortured. Am I correct?
I don't recall.
You don't recall.
No.
And then you were the one who prosecuted them, called several witnesses, and you produced a confession. Is that correct?
Just carry on.
No, I'm asking whether you just tell me. I want it on record that you don't remember.
I recall eyewitnesses and so on.
Yes, you recall eyewitnesses.
As to the specific evidence that was produced, to the detail,
Yes, but there was a confession.
Mm-hmm.
A confession. Okay? And there was a trial within a trial. Mm-hmm. Before the magistrate, Honorable Francis Mabele. Am I correct?
That I remember the trial magistrate was Mabele?
Yes, Mabele. By the way, I was a young boy then. And the issue of torture, they laid evidence of torture at the Nyayo House chambers. Am I correct? You don't recall?
Yes, these are... What year was it? As in, quite a long time ago.
1991.
Yeah.
1990. 1990, I was in Form 4. So, at the Alliance High School. And they laid evidence that they were being tortured. And you resisted that application, of course, as the prosecutor. And the confession was admitted. Am I correct?
Possibly. I'm waiting for the question.
Thereafter, the trial came to an end and they were convicted.
I remember they were convicted.
How many years were they convicted for?
I'm not sure.
Okay. 10 years, 9 years, you don't remember.
No.
So the issue I'm asking, you have told us that in 1982, you were arrested as part of a group of people who were alleged to be coup plotters, people who had taken part in the melee here in Nairobi.
Actually, it wasn't plotters.
Oh, not plotters, but yes, people who are...
Certainly not plotters.
Yes, what I would say, the resgestyle of the coup, the people who are, swept up in all that melee, whatever it was.
That's why you need to be specific. Yeah.
And that is why I'm saying you correct me, because this is historical. I told you I was still a young boy. So you were swept up in that. And from your own words, this was a very pivotal part in your experience, isn't it? So you were swept up in all this maneno of the coup, students rioting or whatever. But it was in that melee of the coup, isn't it?
Just make your question, please.
No. I am putting to you facts.
You are saying things, and some of which I don't recall, some of which may not be true, but I would prefer you get to the question.
No. So if they are not true, you tell me they are not true, because I wasn't there.
Okay, we were not, it wasn't rioting.
It wasn't rioting.
Yes, certainly.
So what were you accused of?
Of taking part in a demonstration.
Taking part in the demonstration. And this demonstration was in relation to what?
The coup.
It was in relation to the coup.
Yes.
And you were brought here to the court, isn't it?
Yes.
Of course, you were denied bail.
Yes.
You went through that harrowing experience.
Yes.
So that is something that it was a big event in your life.
Certainly.
Yeah. So here you are. A few years you come to the DPP's office. The same men, and you recall the same Anyona people had been detained at that time. Am I correct?
I'm not sure in terms of time perspective. I'm not sure.
Yes. So are you aware that at that time Anyona was arrested, 1982?
Generally, yes. But
are
detained,
you aware
I'm not sure
that arrested or detained? You know, you were the adult. I was a child. In fact, in 1982, I was in standard 3. So you have Anyona, you have Edward Oyugi. Had they been subjected to the same issue in 1982? No idea. No. You have Gotho Kariuki. Was he subjected to the same issue in 1982? You don't remember? You have Augustus Kathangu. Was he subjected to the same issue in 1982? You have no idea. So you have been experienced that event. It has been a pivotal part of your life. Then come 1990, you are met with the same or similar circumstances, isn't it? People plotting to overthrow the government. That is what sedition is, isn't it?
Yes.
They've been caught up.
Sedition is not plotting.
So what is sedition? What is sedition?
In the context, it's preaching disaffection.
But isn't that the same genre of threatening a government, a lawful government? It's the same genre, isn't it?
Yeah.
You agree with me? Yeah. So 1982 that happens, 1992, but now you are the prosecutor. And I'm not blaming you for that. Probably somebody has to do your job. You prosecute these men rigorously to the best of your ability.
Rigorously is your word.
Yes, and I'm putting it to you.
No,
vigorously.
I undertook my duties with the necessary competence.
They alleged torture.
Yes.
They alleged that they had been tortured into confessing. And in fact, from the accounts of that day, that trial within a trial took quite some time. Maybe you correct me because you were the one who was there. I wasn't. So the long and short of it is this. 1982, you undergo an experience. 1990, you undergo an experience. Now you want to be Chief Justice. Are you the kind of person we should risk to be the Chief Justice, knowing that these kind of events may happen?
Now,
that is just the question.
Which kind of events may happen?
1982? 1990?
Yes. So which kind of events are likely to happen now?
The kind of events where students like you are picked up from the street, brought to the court after hours, I presume, denied bail, and then told to go home afterwards. Yes. 2, people meeting in a bar, Mutogi bar or whatever bar, arrested and told, you have written a piece of paper, possible nominees for certain cabinet ministers, therefore you want to overthrow the government. Isn't it something, as a Kenyan, in fact, let's go back. Is it something you regret? Is it something you regret? Is it something you have reflected on? Your position in that particular situation?
Commissioner, I want to say this.
Yes.
I was a professional. I was working in the state law office. I was undertaking my responsibilities. You have been an advocate in private practice. I recall, you have done cases which are simply your client's cases. The question of whether or not you agree with your client's case is something that is neither here nor there. Having said that, you have described a trial that took place involving certain individuals. If I was the magistrate, perhaps some of your questions would have been relevant. But I was simply the lawyer advancing a case for one side. There were others advancing the opposite case. So what you call torture, what you call a trial within a trial, was a contested issue upon which there was a determination by a magistrate. If the determination by that magistrate was the opposite or the contrary to his final determination, that would have been a matter that would have been squarely within the purview of the magistrate. I prosecuted a case. The fact that I had an experience that was similar or not has no bearing on the fact that I am now undertaking a responsibility for a client. Otherwise, a lawyer, be he a government lawyer or an advocate, would be totally incapacitated in handling their duties. I conducted a case. There was an outcome.
Okay.
There was a conviction. Where does my personal regret come in? I was doing the duty of an advocate on the government side.
Exactly. And you will be called upon in the future, you may be called upon in such circumstances to do the same duty, isn't it? And you will do it happily.
Actually, you are quite wrong. Quite wrong.
Yes.
How will I be called upon to do the same thing if I'm a judicial officer? How will I be called upon to do it? It's not possible. But as a private sector lawyer, if I was a private sector lawyer, or if I, for any reason, reversed the clock and became a prosecutor, and I had to prosecute a case, I'm not talking about these circumstances, I'm talking about any circumstances, I would undertake my professional responsibilities.
Okay.
Commissioner, the luxury of seeing things from the defense side is always one I find very strange.
So let me just finalize this because my time is up. So we went through experiences, and I'm saying this because I wasn't there, but these issues have been documented. We went through as a country from 1982, 1990, 1991. We went through all these experiences. And for you, when you look back, you're happy to say, I did my duty as a lawyer, and I'm happy with what I did. Is that what I'm saying? And if the same issue arose again, and I was called to prosecute or to do all those things, I would happily do it, isn't it?
If I was interviewing for a prosecutor's job, that would be a relevant question. I am prosecuting for a judge's job. No. So it is far-fetched, and what I'm trying to say, what is the right way? It's a misplaced question.
Okay.
Ask it another way, maybe.
I will not ask it another way. All I'll say is this: a man is his history, and we will judge you accordingly. Thank you very much.
Thank you. Madam Chair.
Yes, Senior Counsel.
Respond. In my years of prosecuting, in my years of defending, I have prosecuted, I have defended across the board. I've even defended the late Wangari Maathai in a case where she was charged against the government, just to show you that mine is the calling of an advocate. I don't judge those who do the case on their side, and those who attempt to judge people should always know that others judge them. So it should be more professional than that. Thank you.
And you are doing your job as a prosecutor that time?
I was certainly doing my job.
Okay, so I think
no one who has not been a prosecutor will understand it.
So I would suggest...
Sorry?
Okay, I'm suggesting commissioners and senior counsel that we take a very short break, maybe 10 minutes. We come back at 11:30, and then we continue with the interview. Thank you.
Thank you.
on the next episode of Ashoka.
Where are you going?
To atone for my father's misdeeds. Father! You are his son. Syama, if you want to take revenge, then you have to treat Bindisar as your father. You even...
Captive. And they have also taken over the palace.
Next on.
Thank you so much for tuning in to Goodnight Show. People on the cycle, people on the bus, people passing fast, in bad and front of us. Read the book. Hyena learns a lesson. I'm going to teach you how to make a chip in a pan. Nichukulie kwa mfano ndani ya matatu. Yaani mtu mzima na miaka zake hizo miaka zote. Mtu ajikwa kuandika note. Note tu peke yake. Kusoma gani utasaidia hapo. Mimi nakusaidia na nini? Nauliza. Ni bwana. Chukia.
Next on.
Mimi talipa. Sio na siwasi bwana. Mimi ndio nimejitolea. Hata wewe ukitaka kunywa. Kunywa. Mwanamume akipenda. Huwa na furaha na nguvu. Hii barua ni yangu, nataka unisomee. Na kama niko na uchawi. Unasemaje barua sasa?
This weekend on KBC Channel 1.
I want to talk about women and the workplace. It is estimated today that women work at least 40 hours every week. And so the workplace has become as important as home. I have a lot of strategies. And the treatment of the cancer, it's very expensive. I know it is not easy, but I pray on God that I'll make it.
We are encouraging private sector companies to support women so that they can challenge their obstacles.
People are getting rid of because of pregnancy.
Yeah.
Can you imagine?
And it starts from leadership of that company.
My name is Joan Wanjiku Aweru. I'm a graduate from the University of Nairobi with a bachelor's degree in arts, specializing in sociology and conflict and peace. I've always been so interested in doing interior design. I like making people's spaces look so beautiful, a place where you feel comfortable, to create an ambience, to make you feel relaxed. Actually, staying in a beautiful space is so therapeutic. And it can even cure depression. When you stay in a place that is so nice and it looks beautiful, you feel happy. I like to make people feel happy. I'm naturally a creative. It's something that I had done for so many years. And then in 2017, I decided to make it an enterprise because people used to ask for more of my art. In 2017, the Tribu Afrique was born. Basically, Tribu Interiors was Tribu Afrique Arts, whereby I started by doing bottle art. I was advocating for environmental conservation, whereby we recycled and upcycled bottles and glasses into space decorations. And then as we went by, I came up with an idea of a clock concept, whereby I came up with a clock that is frameless, and it just sticks on the wall, and it looks luxurious, which is meant to bring beauty in the house and also show time. The material we used for the bottles was thread and paint, which was basically recycling bottles. We used to get them from dump sites, which helped us to conserve environment and also prevent tetanus, because if these bottles are thrown around, meaning you'll step on them and get tetanus. For the clock, we import them, we assemble them, and then now we make the clock. For the art, we just get canvas and then draw. When I was doing bottles, I started reaching out to women living with disabilities. I started to teach them art, bottle art, in order for them to sustain themselves economically. I've trained about 10 women who now are doing their own businesses. There is one that has stuck with me. The ones that I have trained, the 9 of them, I have certified them. And then there's one that remained with me, whom we work with, even with the clocks. I met her when she was doing beads. Now she does bottles. That is, I enhanced her business, and now we are doing clocks with her right now, which makes her an independent woman, meaning she does not have to depend on anyone for finances. Since I graduated, I didn't get a job. So it helps me to be a productive person. I don't idle a lot. I don't idle. So I'm always a productive person because I'm moving from one place to another. We deliver the clocks. We deliver the clocks and install them. So we've gone to different places. We export them to Denmark, England, to different places in the country, that is Mombasa, Kisumu, Nairobi. So we are basically like distributors for this new invention. My mission is to basically create employment to Kenyan youths, because unemployment has become a disaster in our country. So creating employment would be my happiness, and then reaching out to more youths and empowering them with entrepreneurship skills. Tribu Interiors now is what we do is that we do the clock installation. We call it the luxury 3D wall clock because it's really big. It's actually an adjustable clock, whereby we have an auxiliary scale. You just measure. If you want a radius of 30 centimeters, you can do 30 centimeters. You can do 40 centimeters. You can do 50. If it's a radius of 50 centimeters, that means it's a diameter of 100. That's a big clock. have come up with creative designs to make the clock look very outstanding. So it's made of Eva foam and an acrylic mirror, which makes it shine. And then we do the live plant installation, and now the bottle art. The most unique artwork I've done so far is the clock. People are moved by it, and the clock is really the thing that keeps the business going. You know, for the plants, so many people do plants, and so many people do abstract art, fine art. So it's the clock is the one that makes the business really outstanding. My major clients are corporates, and generally everyone that owns a space. It could be an office, it could be a hotel, it could be your house. Yes, it could be a restaurant. Those are my clients. The value of the product is measured by labor, the work I have put into of making the product, and also the price I've gotten the raw materials and assembling it. So that's how I look at the product and price it, and you know, and the profit, the amount of profit that I'm going to make. So this is the clock. It's actually something that really excites me. It's something that I love doing, and I love the concept. It makes me happy. So this is one of the 11 designs that we have. They actually have names. This is design Usman, and it's 1, 2, 3, as you can see. It's removable. You can remove this when you want to move. You just steam it and then it will fall off. When you go to the next house, you just put it. It's shiny. It's made of a material called Eva foam, and this is acrylic mirror, which makes it easy to even wipe. And then when you want to change the battery, this thing is not glued to the wall. You can actually remove it when the battery is over and return it, and it uses just the normal battery. So you just return it, and when you want to set time, you just do it manually because it's a big clock. Let's say it's 6. You just set it like that, and then you give it some seconds, and then it will start moving. You give, and then now it starts to move. So for this clock, it goes for 2,500. In Nairobi, we do free installation. So I just charge 2,500. I come and install. But if it is outside Nairobi, places like Kisumu, Mombasa, I charge delivery free of about 300 for it to get to you. And this clock, it's a do-it-yourself clock. It's something that you can do it yourself. So if I send it to you, you can assemble it and make a clock. The challenges that we are encountering right now is the COVID-19. Because with the COVID-19, we are not able to import our raw materials. Sometimes we run low on finances to be able to import our raw materials. Sometimes we need manpower, and we are not able to employ more people because when we look at our finances, we may not be able to pay the people that we employ. Kenyan art has been underrated. I would say my breakthrough for this particular enterprise came on Twitter, whereby I posted my work. I didn't think people would really love my work because I don't have so many followers on Twitter and not so many people know me. To see my work reach to 100,000 people was my breakthrough, And since then, the business has been going up. We are planning to launch the clock line so that now we can now own the clocks. We are working on rebranding, which will make the Traibu Interiors the first company or the first enterprise to come up with a clock line here in Kenya and even in Africa. People are created differently. There's always how I've learned how to, interact with people from different cultures, from different countries. So when you interact with them, you learn that people are different. People have different beliefs and people have different values, and that really helps me to embrace everything. I get inspired by, Barack Obama. I get inspired by Oprah Winfrey. I get inspired by Washington Denzel. The list is endless. And the late Stephen Hawking, that discovered the black holes. That's a person that really inspires me because he says that there are no limits to the human spirit. My social media handle is Traibu Interiors, like how it's written here. Traibu Interiors. That is on Facebook and on Instagram. On Twitter, I just used my personal handle. That is Shiko88. Shiko with a H and 88. There is beauty in building something from scratch. It has been difficult, but also there has been beauty in seeing it grow day in, day out. It's good that you never give up on your dreams and you never give up on what you're doing. You never know where your work might land you.
Yapo mambo manne ambayo Muislamu anapata kunufaika nayo ndani ya mwezi mtukufu wa Ramadhani. Na Mtume sallallahu alaihi wa alihi wasallam aliwaonesha maswahaba zake namna ambavyo kwamba Ramadhani yao inastahili kuwa.
Tonight on KBC Channel 1.
Go. Easy. Did you do anything to it?
Umesemaga leo ni kujitawala.
Leo ni siku yetu.
Unakaaje? Utajili?
Unakaa poa na hiyo jaketi ya wenyewe. You're in as deep as I am.
This time you're seriously going down.
I don't know about you, Glenn, but I'm not going to jail for any reason whatsoever.
Neither am I.
So either you let me in, or tell Tiffany I need to see her right now.
Come on. Nini inaendelea?
This weekend on KBC Channel 1.
I want to talk about women and the workplace. It is estimated today that women work at least 40 hours every week. And so the workplace has become as important as home.
I have a lot of strategies. And the treatment of the cancer, it's very expensive.
I know it is not easy,
but I pray in God that I'll make it.
We are encouraging private sector companies to support women so that they can challenge their obstacles.
People are getting rid of because of pregnancy.
Yeah.
Can you imagine?
And it starts from leadership of that company.
particularly when it comes to public entities where there's the taxpayers' money involved in arriving at a decision where there are claims. I mean, what are the principles now that come to your mind when is guiding you in that process? Just in a nutshell.
Thank you very much, fellow counsel, commissioner. I haven't reread the award, but my recollection is very clear. I believe the landscape, our legal landscape is replete with similar claims, where when you're looking at the claims, there are so many zeros, but when you focus on the evidence, there is very little to back it. So I mean, for me, my hands are tied. I cannot award in favor of such a claimant. The same principle has always driven me, even as an advocate. And to this extent, I don't attract claimants who have very weak cases, because I interrogate the case. I interrogate the issue, and I always simply say, this is not worth fighting. That's always been my philosophy as a person. The courts, again, what is related to this is I've often heard it said that there are so many claims against the government and so on. And whilst I think in many cases the government deserves to be found liable where appropriate, there should be no hesitation for a court to find otherwise. So really, that's all I want to say about that.
Yeah. Now, public interest cases, because particularly the Supreme Court, if you become our Chief Justice, it's an area that you are likely to have many of those matters. Now, I would want to hear your views regarding balancing private, against the public interest, because an area that we normally are confronted by, I'm not referring to the criminal matters, I'm just referring now generally, because it's an area where even the Constitution itself, it protects private rights, but again, there's the issue of public interest, which has to be balanced. I don't know, in your thought, when this is now your judicial philosophy, what guides you in balancing the two rights? Because this is something you'll be confronted with, every day.
The first thing that one needs to achieve, or one needs to aspire to, if one becomes a Chief Justice, is to have a reputation for being fair. It's a very simple thing, but at the same time can be very elusive. And I want to go back to something I had mentioned earlier. As soon as I joined the Department of Public Prosecutions, you come in with a reputation. If you are known to be corrupt, it comes with you. And as soon as it comes with you, the strangest of people walk into your public office asking for favors. It just happens that way. There's also another flip side of that coin. And in that office, those who cannot work in any other way often ask for transfers or to leave the office. Now, I'm coming to the issue of the office of the Chief Justice. These claims that you're talking about, multi-billion shilling claims and so on, there are many that are genuine, but there are many that are rent-seeking claims, in the sense that they are made for the purposes of somehow procuring the judgment and ultimately getting the payment. I, as a Chief Justice, would like to have a situation where the government is assured that under my watch, fraudulent claims will be carefully handled, scrutinized. At the same time, where claims are deserving of merit, deserving of award, I will be the first person and always the last person to defend the judicial officer concerned. So create a situation where everybody is comfortable. Everybody says, well, if we have that head of the judiciary there, then let's take the judgment, whether it's painful or not. So I want to bring a situation where we sanitize the creeping image of unchecked corruption in the judiciary.
Yeah. Now, I'm trying to go beyond that. I hear you and I associate with what you're saying. But I'm talking about now the public interest component, where you find that sometimes there's the rights that would benefit the public, but there's also the component of the private right. Say, for instance, like public land, that has been not properly, granted to a party. They claim that I'm the third owner, I'm the fourth owner, but again, this the institution, the public interest that has to also be taken into consideration. Probably there's the road, there's like the Mitubel case where they'll say, yes, it's government land, but we've been here in generations. I'm just trying to understand what to guide you without going into how you would rule, because I agree with you. Sometimes it will be difficult for you to take a firm position. Just how do you balance it as you develop, the jurisprudence?
Thank you for the question, Commissioner. I think the Constitution is clear. Public rights override, public interest overrides. Where there is need to compulsorily acquire, compensation must be paid promptly and at the required level of compensation. But on the issue, and I don't want to say too much because there's a big trend of these cases in court. I generally take the view that somebody who has stolen something is incapable of giving somebody good title. And the person who then is deceived and buys this second, third title should have recourse to the person who sold it to him. So that has been my general attitude about these competing claims on public land and so on.
Okay. Now, let me come to the issue of the challenges that we face every day as advocates in courts. But you see, we as advocates, we represent the public, so to speak. Now, I know you've mentioned them generally, but now, I don't know, what are the three key challenges that we are now facing that, you said that the ship is basically coming to a stop. You mentioned about IT and all that.
Yes.
I'm interested in knowing how you'd go specifically into resolving those issues, so that even as you resolve, because there will be those that short, medium term, and long term. There are others that you may not even be able to handle unless, of course, you are funded. But there are those low-hanging fruits, the immediate things that you think you can be able to deal with. And for instance, I would want to hear about this issue of, say, like a transfers. If you come in here, how you'd handle those kind of things, like the transfers in the institution, how you'd be able to deal with the issues of optimal use of the resources that you have, including the human capital, the efficiency issues, because they are ripe issues. Sometimes you may be talking about very big things, but they also the small things that could make a big difference without necessarily even requiring financial resources. So about some three key things that you would do that would quickly make us now start moving in the right trajectory.
Thank you very much, Commissioner. I start with the low-hanging fruit, the one that is free of charge. As much as a lot of stuff has been posted about me, I also read what is supposed to be relevant within this conversation. For example, the memorandum submitted to the Commission, not to me, to the Commission by the KMJA. That is the Kenya Judges and Magistrates Association, whom Commissioner represents on this commission. It is just about leadership. It's just about how that cadre of officers feel taken for granted, how they feel how they felt neglected by the immediate past administration, how they felt their matters of transfers were dealt with in a less than humane manner. I have the memo. It's a whole catalogue of things written with, I'd say, the pain of young professionals. They talk about transfers not considering the age of their families, and I understand that to mean that whilst a few of us here can, because of our age, can work in a different town from their spouse, at a younger age, it is difficult. And they also deal with the transfer policy. I'm aware there are transfer policies, I mean personally, and you would understand why. I'm aware there's a transfer policy in the Court of Appeal. And I have seen how it has affected my own family. But now that there is a transfer policy, anyone's family, and mine included, could plan, because we would have the presence of the matriarch in the house for 2 years, and thereafter she wouldn't be there. I mean, whatever years, whether it's 1 year, 3 years, whatever. So if there isn't a transfer policy, and I'm going into the realm of speculation, it is suggested in that memo that there isn't. A transfer policy should very quickly be developed in the High Court and in the magistracy, and which includes the Qadis, and then it is strictly adhered to, bar the exceptional cases where, of course, for disciplinary reasons or for arresting bad situations, transfers deserve some immediacy. So the human resource issues for existing staff are low-hanging fruit. What it requires is a caring, feeling, walkabout leader, walkabout, just going everywhere to understand the problem and attending to it as fast as possible. It reminds me, as I said earlier, of my tenure when I walked into the state law office in the Department of Public Prosecutions. And the smallest of things change people's attitude towards you, towards their own work. I mean, these days, I noticed there's a lot of food in public service. You go to every corner, there's a mandazi, and if you are in the presence of the commissioners, you might be invited for lunch, and so on and so forth. There's a lot of it. When I was DPP, a small story, the office felt very motivated by the end of the year, and they said they wanted a Christmas lunch. And I said, well, I'll write a memo to the accounting officer and ask if they can sponsor a Christmas lunch for the department that had done very well. And my memo was rejected. My request was rejected. And they said, but we still want a Christmas lunch. And I said, okay, let's do a deal. Raise half the money, and I'll raise half the money as your boss. And the day of the lunch, my personal assistant came and said, they didn't raise any money, but they still want lunch. I had to buy the lunch with no problem at all. But what I'm trying to illustrate is it looks like there is a cadre of officers in the judiciary that feel a little neglected. And that word I use reservedly, a little neglected. That is a low-lying fruit. We need to attend to them, attend to the small things that affect their workspace. And it could just be showing them that you appreciate them. Yeah. The other things that now come to my mind, more substantive, and some might be short-term. You mentioned output and so on, and backlog. Well, maybe we can leave it then. You can ask the next question, and then maybe I'll deal with the bigger issues. You are talking about short-term and medium-term.
About equality, treating everybody fairly, whether high or low, which is good. Now, when it comes to the law, sometimes if we look at the public, the public gets the impression that, even when it comes to the application of law, the high and mighty will be treated differently. The law, will be treated differently. Even when it comes to how bail will be handled, how judgment will be handled, their cases generally, they'll say that it seems like the rich and powerful will get away with issues, But if you are a small guy, you are treated so harshly. Now, I do not know, again, if you are to become our Chief Justice, how you'd be able to go about in ensuring that the institution is seen to be one that is treating everybody the same, even in application of law. Of course, you're not the one who will be determining cases because you'll have many people below you. But you are the leader. At the end of the day, when things are going wrong, they'll be saying it's the Chief Justice who has this institution that only serves the rich and powerful. How would you go about it in restoring that confidence?
Thank you, and this is another good point that requires collaboration at a much higher level. The biggest, what you have just described about rich and poor is it can simply be described as corruption, because the big man or the richer man gets his services, and it is presumed by the smaller man that he has more money. It's not that the system turns a sort of a control button so that it attends to people who have more money and less. No, it simply means those who pay under the table, those who are able to manipulate the system, get their services. You may have seen that in my CV, which I haven't had the occasion to look at. I, at some point, was, and I might be wrong on this, in 2002, I was a member of the National Steering Committee on Anti-Corruption. It is probably time to go back to that point where all arms of government recognize this problem as a fairly acute problem, or a crisis problem, and begin to deal with that. And of course, when you deal with it, it cascades down to the public servants, that everybody is watching them, that you cannot favor anyone over another. You must treat everybody equally. It will be a tall order for the judiciary to turn this around by itself, but it can try. It can try. It can have, of course, mechanisms where people can report this type of discrimination. Yeah, but this requires collaboration with entire government.
Which brings me to the issue of even in our profession, this is something that's a complaint that keeps arising, where some who are more senior can get away with anything and everything. The junior ones have a very rough time, making even sometimes even making their way with, in the institution of the judiciary when it comes to representation. How again would you go about it to ensure that, and this is something that is alive among lawyers generally, where they want everybody also to be treated equally when it comes now to representing their respective clients, regardless of their status, regardless of who they are. Not to say that we don't respect the seniors, of course, that title you possess is one that we all aspire for. But when it comes to representation, everybody is treated the same.
Everybody is treated the same. The lawyers are treated the same, or the clients are treated the same?
The lawyers represent the clients.
Okay.
So you want these lawyers to also be treated the same when it comes now to the services within the institution of the judiciary. There is no lawyer who is given more prominence than the other when it comes to access to justice for their clients.
Macharia, Commissioner, you're putting me on the spot regarding the status called senior counsel.
No, I'm not talking about the senior counsel role. I mean, there are many senior lawyers who are not necessarily having the SC title.
I thank you for that clarification. But I want to say this, and about senior counsel, and I hope they are watching. The privilege of being conferred with the status by the President on recommendation of your peers is one that any senior counsel should exercise with utmost humility. With utmost humility. So that if you go to court and the judge or the magistrate does not call you out, your seniority requires that you simply wait your turn. I've had this discussion with many of them, and the true seniors, I call them the true seniors, who appreciate the fact that with age, with seniority, with experience comes a certain responsibility. All accept that. There are a few senior counsel who go jumping up and down in the court and disrupting proceedings whenever they walk into a court, and they give the senior status a bad name. Now, let me come to the profession of senior lawyers, profession of advocacy. We have a tradition of respecting seniors. And Mr. Njeru, for the Commissioner Njeru, for the time I've known you, which is many years, you have always referred to me as senior, even though I didn't have the status. But because I am, you're senior. This is part of the tradition that has been passed down over the centuries, that allow advocates to be referred to as a noble or an honorable profession. But I'm sad to say that has watered down to almost zero. Today, the lawyers who practice on social media carry the day. When I say carry the day, not necessarily in court, but they take all their arguments out. They browbeat judges, magistrates and judges. When they get their orders, they call the particular magistrate or judge the best. When they don't get their orders, they denigrate the judicial officer. They call them corrupt. They call them gatekeepers. They call them all sorts of nasty names, agents of the state. It's a time for reflection for the profession. There are many solutions to this. Maybe some will involve legislation, but the bar is at crossroads. And in that quarrel, in that melee, in that confusion, these impressions that you're talking about come about. They come about. And if you look at the profession a little closer, it's not even seniors versus so-called juniors and seniors having access. It is a question of those who go around bullying everybody that seem to have the day in court. We need to work on that. The judiciary is the first place that needs to work on it. It needs to slow these people down. It needs to respond to these people. And for example, when an advocate, no matter who he is, no matter how senior he is, whether or not he has 1 million so-called followers, and I put it in quotes because in those situations, they probably don't exist. It's all a virtual world they live in. When you call out a judge and say the judge is corrupt, the Supreme Court is corrupt, I am hoping and expecting that one day, and it might already have happened, I don't know, but I hope the JSC can summon such people and ask them to explain themselves. That way, the profession will clean itself out and be respected.
What I'm looking for, SC, is because see, there's also the debate of the young lawyers actually who also complained to me directly as their representative that they seem to have that when the judiciary is handling them, they are treated differently from the seniors. In terms of the seniors can get away with murder, the juniors. So I'm interested in hearing you as a Chief Justice. How will you drive the message home with the judiciary so that this access to everybody, whether low, whether high, both the public and also these lawyers?
Commissioner, that problem is as old as the profession. When I was growing up in the profession, and all of us were growing up in the profession, there is a tendency to accord the seniors, because of their wisdom and experience and all the rest of it, a little more time. And it becomes a challenge on the part of upcoming lawyers to attain that status or that respect from courts. And when I was a junior state counsel in Kisumu, as much as I was starting out, I made my cases, I made my reputation, and whether or not I was working for the government, I earned my respect. So it's perhaps something we can work on at the JTI whenever there's training. We can ask the judges to be a little soft with regard to perceived preferences, but at the same time, what do they have at the legal profession? It's called what they have, what we attend, the continuous legal education. I think some of our instructors should be able to guide the younger lawyers on what it takes to earn your space, earn your respect before any court.
Yeah,
But otherwise, if it's a question of being there and simply expecting respect to accrue to you, that is probably impossible.
Yeah, but I hope you'd also create a platform to engage lawyers of all cadres.
I recall fondly how Chief Justice Willie Mutunga would be invited to the annual events, the annual events of the Law Society, and I'd be happy if I was a Chief Justice to, spend some time discussing it.
Okay. Now, my last three questions. Now, question number one. You see, if you look at the common law in UK, because this is one of the countries that, does not have a written constitution to date. And the development of the law was generally through the common law, and that's what we even studied in the university and all that. But it was able to shape the country, the commerce and industry, the way, life is, the way people live in the UK. And you can say generally that even that law has been applied in most of the Commonwealth jurisdictions. Now, I don't know if you became our Chief Justice, how you'd go about shaping development in this country in so many spheres using jurisprudence, where we can use the law not necessarily to take over the responsibilities of a parliament, but we're able to interpret the law and develop jurisprudence in a manner that you can see that the country, the judiciary, is playing its rightful role in development of the country. Whether it's human rights, whether it's economic development, the thinking of people and all that, because sometimes the other arms could fail in taking the appropriate steps in shaping how the human society is evolving.
This is something that has cropped up in one form or another in the questions that I've already answered. If it is left entirely to the Supreme Court, it may extend to activism. I think it is more collaborative and should be more collaborative than that. The gaps in the law should be legislated first and contributed to by all stakeholders, of course led by the Honorable the Attorney General, so that the law is written clearly, it is applied in a very easy manner by the courts, and we head in a certain direction. I see the danger of leaving it all to the courts and then having this discussion all the time about activism and whether or not it was what was required or intended by the framers of the Constitution. It is a collaborative idea. It's an excellent idea. I thought you were going to ask me about developing indigenous jurisprudence, and I have noticed in one of the cases where Chief Justice Willie Mutunga was talking about, which was the gender issue, the 2/3 gender issue. Even though he mentioned it, he promptly thereafter continued to quote English cases. So it's not that we wipe out all common law decisions and precedents and disregard them. I think we can always apply them with necessary modifications, and we will proceed in the right way for the betterment of society, and less issues of interpretation. I do agree the judiciary, I do agree the law can play and should play a great role in improving the socio-economic aspects of our country.
Okay, my second last question. Now, there's this issue that keeps arising when it comes to opposition such as yours of the Chief Justice. Should it be somebody from the outside? Should be somebody from the inside? Because the judiciary will all agree also has its own dynamics. Not that I have any position, but I just need you to be able to explain to us. And you see now, when I was looking at somebody like John Roberts, the current Chief Justice of U.S. Supreme Court. And what I noted is that he clerked at some point in time, worked as the Attorney Generals, just like yourself. In fact, I see a bit of that similarity between you and him. Then worked in the White House as a counsel. Then went back to private practice 14 years, argued 39 cases in the Supreme Court, then again appointed as a Court of Appeal judge in the DC Circuit Court, then nominated by, I think it was George Bush who nominated him to go to the Supreme Court, but William Rehnquist died before the process was over, and then he was nominated as Chief Justice. So I don't know whether that's, you could find that probably could disadvantage you in terms of that you're a very good lawyer, there's no doubt about that, probably one of the very best in the country in terms of, understanding the law and arguing your cases with vigor. But perhaps again, because of lacking the judicial experience, somebody could probably argue that it could disadvantage you in terms of the learning curve and understanding the dynamics of the institution, and probably jump to the Supreme Court first, then, become our Chief Justice. I don't know. I would be interested in hearing your response, not to say that I have an opposition on it, but just for you to be able to satisfy this commission that notwithstanding the lack of the judicial experience from the inside, of course you've said that you've related a lot with the judiciary, that it still does not disadvantage you.
Thank you very much for that very good question, Commissioner Njeru. The debate about the insiders versus the outside. Let me go back a little. My favorite example is when I went back to the DPP's office. I was an outsider. I might have started my early life there, knew enough about it, especially where the shoe pinches. And when I came back, I wasn't asking what is the problem. I was simply demanding a solution. I was going to the solution. And there's a small little dimension there as well. We had problems agreeing on terms about my terms of service. And there was an interesting debate because I was taking over from a person who had been at the rank of chief magistrate in this court and had become the DPP. Whilst there was the Honorable Bernard Chunga, who had been a DPP and had moved to become the Chief Justice, and his terms of service at that time were Court of Appeal terms. Listen to the analogy. When I came in and somebody said, here's the job, this is what you will take. And I said, no. And they said, well, why are you fussing? You wanted a job, take a job. And I said, I'm not here for the money. I'm here for doing a job, and I will do it at the level that it is required to be done. It took 5 months for them to see my point, and they gave me the terms. It wasn't much money, by the way. When they increased it to Court of Appeal, as you all know, it's much more even now. But it was the principle. And at some point, in a meeting with the Office of the President, not the President, I'm talking about the representatives, when they wouldn't move, I said, then in that case, I'm prepared to leave and I will work with you as a consultant. And they relaxed a little. I got what I wanted. And just to show you the nature or the kind of person I am, they offered me a permanent and pensionable job. I said, if I can't do it in 3 years, I don't need to be here. And they gave me a contract instead. But that contract was too long. I was sacked in 2 years. Now, I come to the inside-outside discussion in the judiciary. I take my hat off here without any reservation to Chief Justice Emeritus Willie Mutunga for everything he has achieved. Sitting here today, the credit for transformation goes to him unreservedly. And why was he able to achieve the impossible? Because he went in there with a clean sheet, listened to everybody, and could very easily say, then in that case, if that doesn't work, we drop it. As against that, there is the insider candidate, for example. He's done the same thing the same way for 35 years. When you ask him to remove the glass in front of him and he's had it there for 35 years. He says, but how can I do that? How can I do that? So whenever an institution is in crisis, and I believe this one is, a crisis of confidence, crisis of a leadership problem with vis-a-vis other arms of government, the best solution is the outsider who simply comes to ask what are considered silly questions. Why aren't we solving the problem? What is so difficult about X or Y? So this is one of the reasons that informs my application. I should make it very clear that had this judiciary that we all depend on, you got it right, we as practitioners, we as a country all depend on, if I felt it was running perfectly in the right hands, I would have been the last person to apply for the job. Because at my age, I'm going to 60, I enjoy my peace and quiet as a private citizen. Why am I coming here? And whether or not I am a good Chief Justice, I will not please everybody. I will get, as already has happened, people throw stones at you, idlers and other people who have nothing better to do. That is the nature of public service. But I believe at this point in time, you would do very well to have a courageous outsider with the necessary experience. I hope I've answered your question.
And you've answered. Now, my last question. The chair is very strict with time, so that to strictly...
maybe I should add to that last question. And who is also courageous enough to get rid of the cartels that are stalking the court corridors, that are stalking the administration of justice, the brokers for justice. They're all billionaires. They don't even charge legal fees. They're lawyers, many of them. They just charge brokerage fees. People who think they own the courts, and without them the courts can't function. That is what the courts are facing right now. The judiciary is facing that. People are losing hope. You talked about young lawyers losing hope whenever they're in a court and a senior counsel is addressing the court. There are many senior lawyers who now know if they are up against certain lawyers, they don't stand a chance. So what we need is a bit of a shake-up here. We need to move to the next level. We need to restore the transformation journey onto the right trajectory.
Okay, thank you. Now, my last question, if you become the Chief Justice, you'll be our chair here. You'll be the one now to handle this commission. And some of us, including myself, are also difficult when you are fighting, of course, for a position that, you are coming to bring issues that for the people who have elected you as the commissioner is only natural. And also our profession, we are also generally also difficult. So if I don't perform, they put me under pressure. So I also become, difficult here. Now, you will be the leader of the entire institution of the judiciary, the president of the Supreme Court, chairing the National Council of Administration of Justice, So all these different roles that require you to wear different hats. Now, of course, you are aware that there are those who have questioned your temperament. Personally, I've never had any issue with dealing with you, so, it's not about me. But, we are all not the same. Now, there's an opportunity for you probably to answer that question regarding how do you go about it to ensure, because in the LCS in the past, you've narrated how you are the DPP, didn't agree with them. You've projected a journey. So I don't know what kind of an assurance you'd give that you would still be able to, in all these different roles, notwithstanding the questions being raised about your temperament in terms of, handling all these positions, that you'll still be able to do it and let the institutions run, because once you become the Chief Justice, the issue of 2 years like in the DPP does not arise. Removing a CJ is a tall order. You have to run the course. Over to you.
Thank you very much, Commissioner Njeru. First of all, my temperament is a very calm one. And I don't think there's anyone I know, perhaps maybe I know one or two people who have ever seen me get to the point where I have lost my temper. I don't lose my temper. I'm very patient. I'm very, very patient. I give you the classic example. The false accusations by Nelson Harvey, the LSK chairman, suspended LSK president. He has been on my back for the last 1 year. I have not responded to him at all. Because why should I?
Yeah, I'm not sure.
I'm trying to explain that if I'm giving you an example, I don't respond. But when I am finally forced to respond, when I say forced, the commissioner, the JSE commission required me to respond. And if you saw my response, I said it is only because you have asked me. Otherwise, I ignore lies, I ignore insults, I ignore all that. And then I will also tell you, each and every one of the minuscule complaints that have been thrown at me, I've seen some that are 1 line, some that are 2 lines. Apart from being false, I don't know what it is that I'm supposed to have done. But a narrative was being created that I am of short temperament. So I'm coming now to you as the JSE.
JSE, Supreme Court, Judiciary, and NCAJ, particularly, those key offices.
So which one do you want me to start with, in order of hierarchy? Let's start with the Supreme Court. I understand, and I've been listening to some of the questions asked about the Supreme Court. How would I bring collegiality? How will I bring a working relationship? I must tell you, Commissioner, that I am very good at that. I go the extra mile. When I want to bring harmony into a situation, I make the phone calls until I get the audience. I make the phone calls until people sit together. I have been instrumental in providing support for several legal groups, and including the Senior Counsel Bar, and I'm sure almost all of them will say that I'm a team builder. I pull people. I call them. I call somebody 20 times if I have to. So in the case of the Supreme Court, I know I am acquainted with all of those learned and very, very senior and eminently qualified individuals who serve on that bench. And if at all there is collegiality that is not, or the collegiality is not at the required level, I see myself as the right person to bring everyone to the table, working together, agreeing to disagree in a civil manner, so that the best jurisprudence comes out of that court. I delegate a lot. I delegate a lot in the sense that as soon as I got to the DPP's office as DPP, I dispersed my authority. I created sections and departments and allowed people to run with them and report to me only when they had to. So it's not, for me, empire building is not a trait I have. So that I consider, even though first in line, I consider that the smallest of the problems. The JSE is a bigger problem. The 9, 10 of you, or 11 when you finally become 11, are all appointed from big places, elected by powerful institutions, have offices in your own right, like the Honorable the Attorney General, and I can't come and dictate to you. I will have to build consensus around most issues. I have no qualms about, being the big man and having to do it my way. If you ask me that, I often wondered why, when the Honorable former Chief Justice, who had complaints to make to the President or to the public, directed at the public, he stood on those steps alone. I often wondered where was Commissioner Macharia Njeru and team. What am I saying? My approach would be, we all as a commission have to agree, or by way of majority, have to agree that we have a problem, and then we would address if we had to, address the public on that subject together. I believe that is the only way for an institution such as yours. In addition, and now that you ask, I even am aware that there is litigation between some of you. Priority, why does it have to be there? I think those are the things that have to be attended. We must stop this. We must speak with one voice, even when we disagree. So for me, it's a priority area. Nothing can be done without a supportive JSC. Nothing can be done without each one of the JSC members feeling appreciated and whatever. And to make this happen, count on me. I will call you 20 times, even if you are angry and you don't want to speak to somebody else. I will make you come to the table. So for me, that is easy. The NCAJ, National Council of Administration of Justice, I have worked with every one of those. There's quite a huge stakeholder list. So the ones in government, meaning the police, the DPP, the prisons, the probation office, and all those, even the LSK, and all of those, we will work as a team. For me, it's a question of winning, and it's not empire building, it's not having the big car on the block, it's not about trappings of power. I've had those things, they don't mean much to me. In fact, even when I was there, I didn't consider them much. My life didn't change at all.
Okay. I wish you well.
Thank you.
Thank you, Commissioner Jero. I will now request Honorable Commissioner, the Attorney General, to ask his question.
Thank you very much, Honorable Madam Chair. Good afternoon, Senior Counsel.
Good afternoon, Commissioner.
We will continue from where Honorable Commissioner Macharia left off. You've likened the judiciary to a sinking ship.
Pardon me, a stuck ship.
Stuck ship.
Yes.
Thank you for the correction. And you have also identified various areas where you consider there is a crisis in the judiciary. And amongst them is the inadequacy of service delivery, the absence or the decline in confidence, leadership you mentioned, specifically vis-a-vis the executive. You mentioned the cartels and the brokers. So you have identified the problem. What you haven't told us specifically, in the event that your prayer is answered and you're now the Chief Justice and you have walked up the steps you keep referring to, just take 3 areas out of the list that you have enunciated upon and tell us specifically what steps, for instance, practical steps would you take to remove the cartels that you have alluded to bring about, you've mentioned collaboration with the executive and other stakeholders, but you haven't told us the recipe you're going to use. You've mentioned making telephone calls, but how are you going to solve this crisis? Telephone calls may not do it. Over to you, Senior Counsel.
Thank you very much, Honorable the Attorney General, Commissioner. Let's start with cartels, this insidious group or grouping that we talk about year in, year out. Again, I go back to my time as the DPP. Cartels move on when they can no longer feed and feast. So just the fact that the honeymoon is over, they are the first to know. But should they not move on? And I can tell you, and I will not state their names for the record here, they are known. So they will, through EACC and any other agency, be placed under a spotlight. And when the appropriate evidence is found, action will be taken. So, that is the easier part. Of course, they'll fight back, and they'll call us names on social media. But we can live with that. Practical steps, talking about resources and everything else, telephone calls. My Lord, you've challenged me. Without resources, the judiciary cannot move. The ship is stuck. It's not broken. It's not leaking. It is not sinking. It simply needs to be unstuck. And it so happens the manner in which it is stuck can only be removed with, to begin with, the two issues that are no longer elephants in the room. They're the obvious things. Resolving the issue of the 41 judges and having a discussion about resources. Telephone call is a term of art. The last time I checked, it was a very good telephone in the Chief Justice's office that could reach very far. But that's not what will resolve the issue. In fact, it'll probably be used to ask for an appointment. But I would make it even better. Were I to be recommended and finally appointed to the office of Chief Justice, I will not leave State House until I've had a fair discussion on these issues. So I'm not talking about 100 days. I will come within close proximity of the President of this Republic on the day I am sworn in, and that is when the discussion will start. And I appreciate I might not come home with the results that anybody or even I want, but that is a starting point. So for me, it is what is possible, what is achievable, that I will do. So for me, Honorable Commissioner, it is simple. Maybe I go back to the question that Commissioner Macharia mentioned about insiders and outsiders. Outsiders are entitled to some bad manners in terms of protocol, and they can break the protocol and have the discussion sooner rather than later. When you grow up within a regimented system, when you are in an institution such as this, where there appears to be a corporate position taken on the two subjects, and I can tell you that there appears to be, because as I have come for this interview, I have had one or two friends tell me, I hope you are not going to say you will have a discussion with the head of state. And I said, why do you say that? And they said, well, everybody else thinks it's the wrong thing. And I said, well, I make up my own mind. I decide that in my function, in my role as coordinating with other arms of government, I am entitled to make the call, even without the permission of the JSE. But on the final decisions, I'll bring it back to the table and we'll have a discussion with the JSE. So for me, maybe I'm misreading the situation, but I see a fairly simple way out of this. When it comes to funding, Commissioner, Attorney General, we all know what's happening in the government. We all know their limited resources. I would like to go back a little to something that started when I was there, Vision 2030, which is the judiciary dovetails into Vision 2030. And there is an expectation by the year 2030, so much will have been done, with the judiciary having achieved so much. If those plans of Vision 2030 are adjustable, if the government's development programs can be what's the right word, compressed into 4 and only limited projects, it is unfair to imagine that the programs of the judiciary should not equally be affected. But, as has been said, what the judiciary takes is less than 1%. A case can be made for a little more.
Who would you engage
in on this matter?
Mm-hmm.
It would flow from the first discussion I have with the head of state. And I then expect and would request that he authorizes or directs the Treasury to engage us. And once that is done, it'll flow, and finally we'll get to the Appropriations and Budgetary Committee in Parliament, who look at the estimates. But initially, it is the Treasury at the highest level, that is the Cabinet Secretary and his Permanent Secretary.
And if you found that the Cabinet Secretary would not see you?
I would stick to the first, I would go back to number 1, meaning go down to number 2. If you don't, you go back to the head of state. Because I believe he is the only person who can give direction on the subject of reallocation. Why do I say that? You look at the budget of the executive is a whopping, 95% of the entire revenue. So the only money that can be found or can be taken is from the executive. I have a little bit of experience with this.
Isn't that the function of the legislature?
What is this? The allocation?
Mm-hmm.
No.
Talk of teams and teams behind the team. The chase for Emirates FA Cup is on this weekend. Two eventful semi-final matches by England's leading lights are on the cards at Wembley Stadium. On Saturday, 17th of April, Chelsea will clash with Manchester City at 7:30 p.m. Meanwhile, Leicester City will battle it out with Southampton on Sunday, 18th of April at 8:30 p.m. Aptly put, as a team, there is a lot to play for. You either cruise to the finals or get drowned. Live and exclusive on KBC Channel 1. KBC Channel 1, your true sports partner. بسم الله الرحمن الرحيم. السلام عليكم ورحمة الله تعالى وبركاته. الحمد لله رب العالمين، ثم الصلاة والسلام على سيد المرسلين سيدنا وحبيبنا وعظيمنا وصفانا محمد صلى الله عليه وعلى آله وأصحابه والتابعين وتابعيهم بإحسان إلى يوم الدين. Amma baad, watazamaji wetu wapendwa katika runinga yako ipendayo KBC, runinga na idhaa ya kitaifa, na vile vile Waislamu ambao kwamba ni wa msikiti kama huu, msikiti wa Imtiaz Ali. Tumshukuru Mwenyezi Mungu Subhanahu wa Ta'ala kwa neema ya Uislamu, kwa neema ya dini na kwa neema ya uhai. Amma baad, baada bismi na hindi na swala na salamu, qala Allah Subhanahu wa Ta'ala, amesema Mwenyezi Mungu utakatifu wa mawi na sifa zake zote njema ni zake yeye. Ya ayyuhalladhina amanu kutiba alaykumus siyam kama kutiba alal ladhina min qablikum la'allakum tattaqun ayyaman ma'dudat ila akhir al-aya. Allah Subhanahu wa Ta'ala atuambia kwenye Qur'ani tukufu, ya ayyuhalladhina amanu, enyi ambao kwamba mmeamini, kutiba alaykumus siyam, mmefaradhiwa juu yenu kufunga, kama kutiba alal ladhina min qablikum, kama walivyofaradhiwa waliokuwa kabla yenu, la'allakum tattaqun, ili mpate kumcha Mwenyezi Mungu Subhanahu wa Ta'ala. Wapendwa Waislamu, popote mlipo, angalia Allah Subhanahu wa Ta'ala kwanza ametupa heshima kutuzungumzia kwa lugha nzuri, lugha ya kutita, ya ayyuhalladhina amanu, enyi ambao kwamba mmeamini. Kwa hivyo yule ambao kwamba hajaamini hayuko ndani ya aya kama hii. Kisha Allah anatuambia kutiba alaykumus siyam, mmefaradhiwa juu yenu kufunga, kama kutiba alal ladhina min qablikum, kama walivyofaradhiwa walikuwa kabla yenu katika waumini. Kwa nini tufaradhiwe kufunga? La'allakum tattaqun, ili tupate kumcha Mwenyezi Mungu Subhanahu wa Ta'ala. Muislam, nataka kukukumbusha, angalia vile saumu imekukaba leo saumu imekukalia, unatamani upate kunywa maji, lakini hauwezi kunywa yale maji kwa sababu moja tu, kwa sababu unamshukuru na kumheshimu Mwenyezi Mungu Subhanahu wa Ta'ala. Unatamani kula chakula, lakini unawacha chakula kile kwa sababu ya Mwenyezi Mungu Subhanahu wa Ta'ala. Wewe Muislamu, unakuta kwa kuwa kila la kheri unalitaka, lakini hauwezi kulifanya. Unaweza kuwa wewe ni katika wale vijana ambao kwamba damu zao ziko moto, ama ni katika wasichana damu zao ziko moto, una mumeo pale wa halali ama mkeo wa halali pale, na kuna siku mmezoea labda ufika wakati fulani ukafanya mambo mengine, lakini kwa ajili ya Allah unawacha mambo kama yale. Na ndio maana Allah Subhanahu wa Ta'ala akajua kuna watu wengine wavivu, watu wa roho, watu wanapenda kula, akakukumbusha wewe katika watu wa roho, ayyama ma'dudat, ni siku chache bwana. Wacha kuona siku 30 ni nyingi, ni siku chache sana. Angalia leo tangu Ramadhani ianze, leo unakuta Ramadhani inaanza kuondoka. Mpendwa msikilizaji, ni Ijumaa ya kwanza ya Ramadhani, utakuta ikijao itakuwa ya pili, hiyo nyingine itakuwa Jumaa ya tatu, baada hapo itakuwa Jumaa ya nne, itakuwa Ijumaa zimetuondoka, Ramadhani imetuondoka. Kwa hivyo mpendwa msikilizaji, kitu tunakuomba ni kwa kuwa ujibidiishe katika mwezi mtukufu wa Ramadhani kuweza kufanya yale Allah Subhanahu wa Ta'ala amekufundisha, na Mtume Muhammad sallallahu alaihi wasallam anatuambia, Mwenyezi Mungu Subhanahu wa Ta'ala anasema, kwa kuwa as-sawmu li wa ana ajibihi, saumu ni yangu mimi na mimi ndio nitalipa kwa hii saumu. Mpendwa Muislamu, angalia Mtume Muhammad sallallahu alaihi wasallam alikuwa idha kana awwalu layla min Ramadhan, ikiwa ni usiku wa kwanza wa Ramadhan, watu wanapoona tu mwezi, alikuwa anakusanya maswahaba zake na anawaambia, idha kana awwalu layla min Ramadhan, ukiwa usiku wa kwanza wa Ramadhan, futihat abwabul janna, ufunguliwa milango ya pepo, falam yughlaq minha babun, haifungwi mlango wote wa pepo, inakaa iko wazi kabisa. Wa ghulqat abwabu jahannam, na inafungwa milango yote ya jahannam, falam yuftah minha bab, hakuna mlango wa jahannam unafunguliwa. Wasufidat shayatin, na mashetani wanafungwa pingu. Wayunadi munadi, na analingania mwenye kulingania, ya baghi alkhairi aqbil, ewe mwenye kutaka kheri njoo. Wa ya baghi alsharri adbir au aksir, na wewe mwenye kutaka shari ondoka kabisa. Wapendwa Waislamu, kitu tunachosema ni kwa kuwa katika Ramadhani ni mwezi wa watu kufanya mambo ambayo kwamba yanastahiki, kufanya mambo ambayo kwamba yanamridhisha Mwenyezi Mungu Subhanahu wa Ta'ala. Kama wewe labda ni Muislamu mpya ama ni mtu ambaye si Muislamu, unashangaa kufunga ni nini? Kufunga si chakula peke yake na maji, la, mtu anafunga kutumia kitu chochote ambacho kitaweza kupita kwenye mdomo kikaingia tumboni. Kwa hivyo hata peremende huwezi kuweka kwenye mdomo, hauwezi kuchukua chewing gum ukatia kwenye mdomo, kwa sababu utakuwa unafanya makosa mbele ya Allah Subhanahu wa Ta'ala. Hauwezi kusema wacha nichukue maji kidogo tu nipige, maadamu kinapita mdomoni kuingia tumboni, basi saumu yako hakuna. Vile vile hauwezi kuvuta sigara, vile vile hauwezi kula miraa. Vile vile mpendwa mtazamaji, ukiwa ndani ya saumu hauwezi kustarehe na mke wako. Unaambiwa usiangalie uchafu. Ukiona vitu vizuri vinapita mbele yako, fumba macho yako. Mpendwa Muislamu, wewe kama mwanamke au mwanamume, fumba macho yako na ujiweke mbali sana na haramu, kwa sababu huu ni mwezi ambao kwamba Mwenyezi Mungu Subhanahu wa Ta'ala kila unalolifanya anakulipa mara 27. Kwa hivyo jibidiishe. Hata Mwenyezi Mungu Subhanahu wa Ta'ala alisema kullu amal, kila amali inalipwa mara 27 katika Ramadhani, hata mpaka mara 100. Lakini akasema as-sawmu li, saumu ni yangu mimi, wa ana ajzi bihi, na mimi ndio nitalipa saumu. Kwa hivyo wapendwa Waislamu, wapendwa watazamaji, tujibidisheni kufunga, na ujue Mwenyezi Mungu Subhanahu wa Ta'ala kuna watu ambao kwamba amewapa udhuru, akasema faman kana minkum maridan au ala safar fa iddatun min ayamin ukhra. Faman kana minkum maridan, yeyote anayekuwa katika nyinyi ni mgonjwa, au ala safar, ama yuko ndani ya safari, fa iddatun min ayamin ukhra, unaruhusiwa kuweza kuhesabu katika siku zinazokuja kulipa. Fa iddatun min ayamin ukhra. Wa ala alladhina yutiqunahu, na kwa wale ambao kwamba saumu ni ngumu sana, fidyatun ta'amu miskin, unaruhusiwa kutoa fidya, kulisha maskini, ewe Muislamu. Kwa hivyo wewe jiangalia hali yako, lakini isiwe wewe ni katika wale watu ambao kwamba wanajifanyia orientation, wanajifanyia vile vile matayarisho ya kuwa wagonjwa. Kuna watu ambao kwamba Ramadhani ikiwa haiko wao ni wazima kabisa, lakini Ramadhani ikija ndio wanakuambia mimi nina alsa, mimi nina sukari, mimi nina pressure. Mbona miezi ambayo kwamba si ya Ramadhani huyu na maradhi hayo? Kwa hivyo mpendwa wa msikilizaji, jiangalie mwenyewe hali yako. Ukiona hali yako ni ngumu, wewe hasiha yako, afya yako haikuruhusu kufunga, basi unaruhusiwa kula. Lakini ule vipi? Na kutahadharisha wewe ambao kwamba ni mgonjwa, ama yule ambao kwamba anasafiri zaidi ya kilomita 84, usikae katika hoteli watu wengine wanaagiza chakula na wewe unaagiza. Ama wewe umekaa mahali unapita karibu ya msikiti, au unaanza kuambia watu wacha mimi nile. Hilo ni kosa kubwa sana. Unatakana wewe Muislamu, ikiwa wewe ni katika wale umeruhusiwa kutofunga, basi tafuta mahali pa faragha ujifiche ule. Kwa nini? Kwa sababu Allah Subhanahu wa Ta'ala asema waman yu'adhim sha'air Allah fa innaha min taqwa alqulub, yule ambao kwamba anaadhimisha, anatukuza, anaheshimu vitu alivyoweka Mwenyezi Mungu Subhanahu wa Ta'ala, hiyo ni jambo la takwa. Kwa hivyo Ramadhani ni mwezi wa baraka, Ramadhani ni mwezi wa heshima, Ramadhani ni mwezi wa kufunga. Usifanye wale ambao kama si Waislamu waende wakitukana Waislamu, wanaenda wakisema mnasema nini nyinyi hawa Waislamu. Kuna wengine wanafiki hawafungi, ama wewe unavaa kanzu unaingia katika baa kunywa pombe. Usifanye mambo kama hayo mpendwa mtazamaji. Mpendwa mtazamaji, ukivaa kanzu ni nguo ya heshima, basi fanya mambo ya heshima. Ukivaa kofia kama hii usiingie baa nayo, kwa sababu utaleta matatizo. Ikiwa wewe ni mtu ambaye kama hujafunga, basi jifiche ule, kwa sababu ile kujificha kula ndio una udhuru, kwa kuwa wewe ni mgonjwa, ama wewe ni mama mjamzito, ambayo umeambiwa na daktari usifunge, ama wewe uko ndani ya safari ambayo kama ni ngumu, ile kujificha unamstahi Allah, na Mungu atakuletea baraka kubwa kwa kuweza kumstahi Mwenyezi Mungu Subhanahu wa Ta'ala na kuwastahi wale waumini. Kwa hivyo mpendwa Muislamu, tujiwekeni katika hali ambayo kama ni mzuri, na tusiwe watu wa hasira. Kuna watu wengine wakifunga, unamkuta mtu mchana mzima amekasirika, ukimwambia kitu chana mimi wewe, hujui namna saumu yanipiga mimi. Ndio unaona watu wengine wanakwambia pole ya saumu. Hakuna pole saumu. Mtu unapomwambia mtu hongera kufunga, kwa sababu kufunga ni thawabu kubwa sana mbele ya Mwenyezi Mungu Subhanahu wa Ta'ala. Mwenyezi Mungu Subhanahu wa Ta'ala ametupenda sisi. Na kwa nini saumu tuliwekewa? Tumewekewa saumu ili tupate kukusanya thawabu zilokuwa katika hii dunia. Ndiyo Mtume Muhammad sallallahu alaihi wasallam asema, man sama ramadhana imanan wa ihtisaban ghufira lahu ma taqaddama min dhanbi wa ma ta'akhkhar. Man sama ramadhan, mwenye kufunga mwezi mtukufu wa Ramadhan imanan, kwa kumwamini Mwenyezi Mungu Subhanahu wa Ta'ala, kuamini fadhila za mwezi mtukufu wa Ramadhan, unaambiwa nini? Unaambiwa ghufira lahu ma taqaddama min dhanbi, unasamehewa madhambi yalotangulia. Na baadhi ya ulama wanakwambia hata madhambi yanayokuja utasamehewa ni Mwenyezi Mungu Subhanahu wa Ta'ala. Lakini uwe wewe ni katika watu ambao kwamba wametia nia kutofanya madhambi kabisa. Kwa hivyo nia yako ikiwa mzuri, inakuwa Mwenyezi Mungu Subhanahu wa Ta'ala naye amekufanyia mema. Sasa kuna baadhi watu husema, ikiwa Ramadhani milango yote imefunguliwa ya pepo, ya nini mimi nijifanye ati kufanya mambo ya kheri kama milango imefunguliwa? Haijafunguliwa kwa wale wasifanya kheri, imefunguliwa kwa wale wenye kufanya kheri. Ndio unaambiwa, malaika wanasema, ya baghi al khairi aqbil, ewe mwenye kufanya kheri njoo karibia katika pepo. Wa ya baghi ya shar, na wewe mwenye kutaka shari adbir ama aksir, ondoka na upotee kabisa. Kisha watu wanasema, mbona kunatokea baadhi ya watu wanafanya matatizo na madhambi ndani ya mwezi mtukufu wa Ramadhani? Wamefungwa wale mashetani wa kisasawa, lakini kuna mashetani, wajua mashetani wako aina mbili, minal jinnati wan nas. Wengine ni katika wale majini wamefungwa, lakini mashetani wa kibinadamu bado wako. Ndio unakuta wanakushawishi, twende tukaibe, twende tukafanye hivi. Kwa hivyo waepuke watu kama hao. Mpendwa wa Muislamu, wewe jiepushe na mambo yote maovu katika hii Ramadhani, na pia mwezi mtukufu wote wa Ramadhani ujiepushe na matatizo ambayo kwamba yatakuwa unapambana nayo. Mwenyezi Mungu Subhanahu wa Ta'ala atambia kwenye Qur'an, fa idha quri'a al-Qur'anu fastami'u lahu wa ansitu la'allakum turhamun. Wa qala Allah Subhanahu wa Ta'ala, fa idha qara'ta al-Qur'ana fasta'idh billahi minash shaitanir rajim. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Wal 'asr innal insana lafi khusr illa alladhina amanu wa 'amilus salihat wa tawasaw bil haqq wa tawasaw bis sabr. بارك الله لي ولكم بالقرآن العظيم ونفعني وإياكم فيه من القرآن والذكر الحكيم. أقول قولي هذا وأستغفر الله لكم فاستغفروه إنه هو الغفور الرحيم وهو البر الكريم. الحمد لله وكفى وصلاة وسلام على عبده المصطفى صلوات الله وسلامه عليه وعلى آله وأصحابه والتابعين وتابعيهم بإحسان ila yawmiddin. Amma baad, ndugu watazamaji ambao mnatizama kutoka mahali popote katika idhaa yako pendayo KBC, na vile vile Uislamu ambao kwamba umejaaliwa kuweza kuswali katika msikiti, tunakushukuru sana, na salamu zikufikia kutoka katika msikiti wa Imtiaz Ali. Wapendwa Waislamu, Mwenyezi Mungu Subhanahu wa Ta'ala katika Qur'anul Karim, kama tulivyoeleza tulivyoanza katika ile khutba ya kwanza, tukakwambia Allah Subhanahu wa Ta'ala amewakumbusha Waislamu akawaambia, ya ayyuhalladhina amanu kutiba alaykumus siyam kama kutiba ala alladhina min qablikum la'allakum turhamun. Ewe Muislam, usi nafsi wa usikum bitaqwallahi azza wa jalla faqad faza almuttaqun. Usi nafsi, na yusia nafsi yangu na nausia nyinyi kumcha Mwenyezi Mungu Subhanahu wa Ta'ala. Na unaona Mwenyezi Mungu katika kila jambo anatutegemezea kumcha yeye, kurudi kwake. Ndio akatwambia, ya ayyuhalladhina amanu, enyi ambao kwamba mmeamini, kutiba alaykumus siyam, mmefaradhiwa juu yenu kufunga, kama kutiba ala alladhina min qablikum, kama waliofaradhiwa walikuwa kabla yenu. Kwa nini? la'allakum tattaqun, ili mpate kumcha na kumwogopa Mwenyezi Mungu Subhanahu wa Ta'ala. Kwa hivyo takwa ni kitu kikubwa sana ambacho lazima tuweze kukifuata. Wapendwa wa Uislamu, tunakumbushana kwa kuwa Mtume Muhammad sallallahu alaihi wasallam alikuwa anasema ikija Ramadhan, ja'akum shahru Ramadhan, imewajia nyinyi mwezi mtukufu wa Ramadhan, shahru baraka, mwezi ambao kama ni wa baraka, yaghshakumullahu fihi, Mwenyezi Mungu Subhanahu wa Ta'ala anawafunika nyinyi katika mwezi mtukufu wa Ramadhan kwa rehema zake. Tatanafasukum yanzurullahu tanafusakum, Mwenyezi Mungu Subhanahu wa Ta'ala anatizama kushindana kwenu katika mambo ya kheri, fihi, katika mwezi wa Ramadhan. Fayubahi bikum malaikata, Mwenyezi Mungu Subhanahu wa Ta'ala anawaita malaika, anawaambia njooni muone, anajifakhiri kwao, anawaambia fa'arullaha min anfusikum khairan, nyinyi Waislamu shindaneni kumuonyesha Mwenyezi Mungu Subhanahu wa Ta'ala katika kushindana kwenu katika nafsi zenu mambo ya kheri. Fa inna shaqiya, mtu ambao kama ni shaqi, man hurima fihi rahmatullah, ni yule ambao kwamba amenyimwa rehma za Mwenyezi Mungu Subhanahu wa Ta'ala. Kumbuka mtume wetu Muhammad sallallahu alaihi wasallam alituambia kuhusu mwezi mtukufu wa Ramadhan, akatuambia awwaluhu rahma, mwanzo wake ni rahma, wa awsatuhu maghfira, na katikati yake ni maghfira, wa akhiruhu itqun minan nar, na mwisho wake ni kuachwa na moto. Kwa hivyo wewe mpendwa Muislamu, hakikisha umeingia katika wale ambao kwamba wanazungumziwa ni Mtume Muhammad sallallahu alaihi wasallam. Akatuambia man swama ramadhana, mwenye kufunga mwezi mtukufu wa Ramadhan, imanan wa iman wa ihtisaban, na kutaka thawabu kutoka kwa Mwenyezi Mungu Subhanahu wa Ta'ala, ghufira lahu ma takaddama min dhanbi, atasamehewa madhambi ambayo kwamba yametangulia kutokana na madhambi yake. Wa man qama ramadhana, na mwenye kusimama katika usiku wa Ramadhan kwa kuswali tarawih, kwa kuswali tahajjud, kwa kuswali witri, imanan, kwa kuwa ana imani, kwa kuwa anafanya haya kwa sababu ya Mwenyezi Mungu Subhanahu wa Ta'ala, wa ihtisaban, na kwa sababu ya kutaka thawabu za Mwenyezi Mungu Subhanahu wa Ta'ala, ghufira lahu ma takaddama min dhanbi, Mwenyezi Mungu Subhanahu wa Ta'ala atamsamehe madhambi yake ambao kwamba yametangulia. Wa man qama lailatal qadri, na hapa ndio muhimu zaidi, wa man qama lailatal qadri, na atakayesimama katika lailatul qadri, imanan wa ihtisaban, kwa kutaka iman na kutaka thawabu za Mwenyezi Mungu Subhanahu wa Ta'ala, ghufira lahu ma taqaddama min dhanbi, anasamehewa madhambi ambayo kwamba yametangulia katika madhambi yake. Kumbuka mpendwa Muislamu, na tutakuja kuzungumzia Lailatul Qadri mbele, lakini mwenye kupata Lailatul Qadri atakuwa amepata thawabu za miaka 83. Ni wangapi katika sisi leo hawataka kupata bonus kutoka kwa Allah Subhanahu wa Ta'ala kupata thawabu kama hizi? Mpendwa Muislamu, Mwenyezi Mungu Subhanahu wa Ta'ala anasema katika hadithi yake tukufu, hadithi al-Qudsi, kullu amali ibn Adam, kila amali ibn Adam lahu al-hasana bi'ashri amthaliha, anapata thawabu mara 10 ya kile ambacho kwamba anakifanya, ila 700 dhifin, mpaka mara 700, illa siyam, isipokuwa saumu, fa innahu li, Allah Subhanahu wa Ta'ala sema saumu ni yangu mimi, wa ana aji bihi, na mimi ndiye nitamlipa. Nini Allah anaongeza? Anasema taraka shahwatahu, ameacha matamanio yake, wa taamahu, na chakula chake, wa sharabahu, na kinywaji chake, min ajli, kwa sababu yangu mimi. Liswaini farhatani, mwenye kufunga ana furaha mbili. Farhatun inda fitri, furaha ya kwanza ni pale anapofungua, mtu anaona raha anapofungua, kwa kunywa maji baridi, kwa kula tende, kwa kula chakula, anaona raha. Wa farhatan inda liqa'i rabbi, na furaha pili ni siku ambayo kwamba tutakutana na Mwenyezi Mungu Subhanahu wa Ta'ala. Ikiwa tulikuwa tunafunga, tutakutana naye siku ya Kiyama, na huku tunafurahi, tunatabasam. Na Mtume Muhammad sallallahu alaihi wasallam akakwambia, wala khalufu famiswa'in, hakika ya harufu mbaya inayotoka katika harufu mdomo wa mtu ambaye kama amefunga, atyabu inda Allah, ni bora mbele ya Allah Subhanahu wa Ta'ala, min rihil miski, kuliko harufu ya miski. Kwa nini Allah aseme haya na kwa nini Mtume Muhammad SAW asisitize? Ni kwa sababu mtu yote kama hajakula huwa anatoa harufu mbaya kwenye mdomo. Sasa kuna watu wanasema siwezi kufunga kwa sababu natoa harufu mbaya. Usishtuke, ile ni bora mbele ya Allah kuliko chochote katika dunia hii. Ayuhal muslimun, udhakirukum bi amrin bada'a fi binafsi وثنى بملائكة نكذب بالقدس وثلث بالمؤمنين فقال الله سبحانه وتعالى إن الله ملائكته يصلون على النبي يا أيها الذين آمنوا صلوا عليه وسلموا تسليما اللهم صل على سيدنا محمد وآل سيدنا محمد كما صليت على إبراهيم وآل إبراهيم وبارك على سيدنا محمد وآل سيدنا محمد كما باركت على إبراهيم وآل إبراهيم في العالمين إنك حميد مجيد. وارض اللهم عن الخلفاء الأربعة سيدنا أبو بكر الصديق وسيدنا عمر الفاروق وسيدنا عثمان بن عفان وسيدنا علي بن أبي طالب. وارض اللهم عن الحسن والحسين وأمهما فاطمة الزهراء وجدتهما خدة الكبرى. وارض اللهم عن سائر صحابة رسول الله وآل رسول الله والتابعين وتابعيهم بإحسان إلى يوم الدين. اللهم ربنا تقبل منا إنك أنت السميع العليم وتب علينا يا مولانا إنك أنت التواب الرحيم. اللهم أعز الإسلام والمسلمين وأذل الشرك والمشركين وأهلك أعداءك أعداء الدين برحمتك يا أرحم الراحمين. اللهم اغفر للمسلمين والمسلمات والمؤمنين والمؤمنات الأحياء والأموات برحمتك يا أرحم الراحمين. عباد الله إن الله يأمر بالعدل والإحسان وإيتاء ذي القربى وينهى عن الفحشاء والمنكر والبغي يعظكم لعلكم تذكرون. فاذكروا الله الذي يذكركم واشكروه على نعم يزدكم ولذكر الله أكبر والله يعلم ما تصنعون. وأقم الصلاة.